This morning, good morning to everybody. We're here this morning for first appearance. I'm Judge Carpenter Toy. I'm going to start with, looks like Wendy Pierre Louise. Tell me which, is he in the main jail?
Good morning, Judge.
Good morning. They asked me to call out of order Wendy Pierre Louise.
Yes, Judge. Hold on one moment. And also, he declined to serve as a public defender, Judge.
Okay.
Page 24.
Is he there?
Yes, he's approaching.
Okay. Hi, good morning, Mr. Pierre Louise.
Good morning.
Good morning. You're here this morning charged with aggravated assault.
How I aggravated assault when it was a petty theft?
And also,
I never touched no one.
Also charged with a petty theft, yes.
Yeah.
Okay, so I do find probable cause. And as to the aggravated assault charge, the set bond in the amount of $5,000. And no contact with the victim in this case.
I ain't got no money at all.
Okay.
Your Honor,
I'm a bond out without no money.
Yes, sir.
If I may, I would just ask for just 2 additional conditions: no return to the property, the incident location, and
they got the stuff back too. They got the items back too. I ain't got their items.
And then Mr. Pierre Louise not be in possession of any firearms, weapons, or ammunition until further order.
I'll be running by kid ass too, ain't it?
Okay, Mr. Pierre Louise, I'm going to order a $5,000 bond, and there's going to be no contact with the victim, and I'm going to order that you not return to the location where this happened, okay?
Okay, ma'am.
Okay, and if you'd like to, you can talk to the public defender's office about their representation.
Fuck that shit. I don't want to talk that shit.
Okay, sir.
All right, Missy. Thank you.
Uh-huh. So do it. I just put the conditions right on there, and I need to sign it.
So you don't have to write conditions.
Okay. Just put it right there, is okay? All right.
Towards the back. I don't
Next we have Allison Pfeiffer.
Ms. Pfeiffer is here, approaching, Judge. Here at me.
Judge, I'm her boyfriend.
Hi, good morning.
Yeah, absolutely.
Sure, would you just state your name for us?
Yes, ma'am. I'm John Carroll.
Okay, Mr. Carroll. Ms. Pfeiffer, you're here this morning charged with touch or strike battery, dating violence. And
Hey, so I just want to let you know
tell me your last name again, I'm sorry.
John Carroll.
Okay.
We moved here from Louisville, Kentucky. We've been here for about 2 months. Drank a little bit last night, got in a little bit of an argument. It was
Judge, we're having a hard time listening to the witness.
Okay. Maybe, hang on a second, they need to be able to hear you. Can you, that microphone right in front of you?
I just like her home. It was an accidental thing. She's my girlfriend, the love of my life. I'm going to put a ring on. Like, she's a smart girl. She's in college, almost done with her bachelor's degree in hospitality and management. We moved here 15 and a half hours away. This was an accidental thing. It wasn't even her fist or anything. It was clothes that I was being angry with her.
Rather than talk about the case right now, I just want to let you know. Do you have anything, counsel?
Yes, Judge. We're going to be asking Your Honor to consider releasing Ms. Pfeiffer on her own recognizances or on the alternative pretrial release. My understanding is the victim is here. He doesn't seem to be in fear of his life or anything like that. I'd ask you not to impose a no-contact order. At this time, my understanding is they do live together. My understanding is she is not working. She depends on her boyfriend for all her financial support. As you heard, she is going to school online. She's studying hospitality. She was working before. She was working for Kroger. She left that to try and find, complete her college education and then find some sort of employment in the hospitality field. She has no prior record. So on this misdemeanor offense, I think it would be reasonable to consider an ROR or to release her to pretrial release, Judge.
Okay, Mr. Carroll, if you would raise your right hand, sir. You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down.
Yes,
Mr. Carroll, do you have any fear of Ms. Pfeiffer?
Not at all.
Okay. Would you like to have contact with her?
I would love to have contact with her.
Okay, I'm gonna release her on her own recognizance. I am gonna order that she contact pretrial release and that she be on standard pretrial release to call in. How many times would that be standard? 2 times per week.
Yes,
So Ms. Pfeiffer, when you do get released, you're going to need to make contact with pretrial release, and you will need to call them twice a week, okay?
Okay, thank you, ma'am.
And Judge, can you order that she report to pretrial within 24 hours?
Within 24 hours, she should report.
Does it matter? Get released or?
Thank you, sir.
Yeah, do you know when, she can get out or whatever, like?
If you go over to the jail, maybe they'll be able to help you, or maybe one of the attorneys right here can talk to you about that. No, I'm not making it. I have a next Ursula Lillian Moore. Ursula Lujan Moore. Hi, good morning, sir. Is she at North Broward?
Yes, Your Honor. Ms.
Okay,
Moore is at North Broward.
thank you very much. Good morning, Ms. Moore.
Good morning.
Ms. Moore, you're here this morning. You're charged with touch, strike, battery, domestic violence. I do find probable cause as to that charge. Sir, if you would, your name, please?
Good morning, Your Honor. My name is Jimmy Moore, the husband of Ursula of 20 years and the alleged victim.
Okay. Mr. Moore, what is it you'd like to tell me this morning?
Well, we're a little scared and nervous. I made a few notes. Can I read it?
That's okay. You don't need to be scared or nervous. I'm happy to hear anything you have to say.
So again, my name is Jimmy Moore, husband of 20 years of the defendant Ursula Moore, and I'm also the alleged victim in this case. Our sincerest apologies to the court and to Royal Caribbean Cruise Lines for this situation that was reported last Monday, May 28th, on our vacation cruise. We believe this is a terrible misunderstanding that will be resolved once all the evidence and facts are revealed. Your Honor, we humbly and sincerely request your consideration for Ursula's release on our own recognizance. Your Honor, we pledge to you, to the state of Florida, that this loving lady, nor I, are of no risk, flight risk. We are both Florida residents of the last 15 years, business leaders and volunteers in our community in Clearwater, Pinellas County. Both my son and I are both Army, our oldest son and I are both Army veterans. Ursula Moore is a loving mother of 4, children are waiting at the hotel, and a wife of 20 years, no criminal history, no prior arrest records, has never harmed anything or anyone in her entire life.
Okay, Mr. Moore.
We pledged to you to be, we pledged to be no risk to our family or to the public and continue loving relationship with, and work closely in cooperation with your court system with the state of Florida, if you allow her to be released today on her own recognizance, and allow us to go home together with our family, my mother, our 4 kids.
Okay, Mr. Moore, thank you for being here. Could you raise your right hand for me, sir? Do you swear or affirm to tell me the truth?
Yes, ma'am.
If you would, please tell me, are you in any fear of Miss Moore in any way?
Absolutely not. We slept in an 8x10 cruise cabin for the last 7 nights
no
together.
is sufficient.
No.
Okay, you can put your hand down, sir. Thank you. Is the public defender's office there on behalf of?
Yeah, I just spoke with Ms. Moore. She did indicate she has no prior record. She's been a Florida resident for 15 years. They have 3 children, 17, 14, and 9 years of age. They do live in Clearwater. Based on what Mr. Moore has said here this morning most eloquently, I would ask the court not to impose a no-contact order. I'd ask the court to release Ms. Moore on her own recognizance. I don't know if the state has an objection to that.
State?
Your Honor, I would be requesting a no-contact order. I don't know if there's some confusion or something here, but it does appear, and I'm not saying it's significant, I'm just mentioning it because the representation is that there's been nothing in the past. There was some type of municipal ordinance out of Pinellas County in January of this year involving unlawful false alarms. I mean, I can't see what it was about.
Okay,
Addressing.
I have read the probable cause affidavit. I do find probable cause. I am going to release her on her own recognizance, and I am going to allow her to have contact with Mr. Moore. However, Ms. Moore, it is going to be your responsibility to make sure you come to court and answer to this charge, because it will still be pending here in Broward County, even though you're going to be residing at home in Clearwater. So I'm going to release her on her own recognizance. Thank you for being here, Mr. Moore.
Your Honor.
Thank
No
you.
pretrial. David Anthony Goodman. Where's Mr. Goodman?
He's here present, Judge, at Maine.
At Maine?
Yes, Judge.
Good morning, Mr. Goodman.
Good morning.
You're here charged with touch, strike, battery, dating, violence. I do find probable cause for that. I will hear from you. Counsel?
Yes, Judge. I'm going to be asking for the court to set a bond of $1,000 on Mr. Goodman's behalf, and this is the reason why. My understanding, he has no prior record. He's 29 years old, been living in our community for about 5 years now. Him and the alleged victim do live apart from each other. He lives in Fort Lauderdale, so there's not going to be any sort of risk as far as him having any sort of contact, and he'll abide by the court's order. He's right now presently collecting disability. He gets about $700 per month. Besides that, what he's trying to do, he's going to Palm Beach College. He's trying to study business tech. He pays for that through financial aid. So right now, financially, he has really no sort of monetary resources. He's going to be contacting his brother, who he lives with, to help post his bond. So he believes that maybe his brother can come up with a $1,000 bond. We believe that's reasonable under the circumstances.
State, do you have any priors?
Your Honor, there was an arrest in 2012 for domestic violence battery against a different alleged victim. The charge was dropped.
Okay. All right, I do find probable cause. I will set bond in the amount of $1,000. I am going to order Mr. Goodman to have no contact with the victim in this case. That's either direct or indirect. You understand, Mr. Goodman?
Yes, ma'am.
Okay.
Thank you, Judge.
Tremaine Jamar Brantley.
He's approaching, Judge.
Good morning, Mr. Brantley.
Good morning.
You're here charged with battery, causing bodily harm, domestic violence. I do find probable cause for that charge. Counsel?
Judge, we're going to be asking for $1,000 bond on his behalf. I believe this is his first arrest. He's a registered voter here in Broward County. Him and the victim do live apart from each other. I believe the victim lives in Fort Lauderdale. He lives in Lauderhill with his brother. He's going to be contacting his brother, who works at Dunkin' Donuts, to help his monetary bond, and that's the reason why we're requesting a $1,000 bond.
State.
Your Honor, there's no history, but I am concerned about the allegations that he punched the alleged victim in the face and head approximately 3 times, and this is about 2 weeks after giving birth to their child.
Okay, I do find probable cause. As I said, I am going to set bond in the amount of $1,500. I am going to order that Mr. Brantley have no contact with the victim in this case, either direct or indirect. You understand that, Mr. Brantley?
Yes, ma'am.
Okay. Robert Thomas Norris.
Yes, he's here present, Judge.
Ms. Machado?
Good morning, Mr. Norris.
Good morning.
Mr. Norris is charged with assault, domestic violence. He's charged with assault, although the probable cause affidavit appears to allege a battery.
For all I know, the officer might be from up north where they classify that as an assault. Your Honor, I would be asking the court if you could write in on the findings, because I do believe there is probable cause for battery.
I do believe there is probable cause for battery. I don't believe there's probable cause for an assault. So when you say you want me to write it in, you're saying the state's asking that I change the charge to battery?
Well, it wouldn't be, it technically wouldn't be a change of charge, because once BSO books someone in under a charge, the only point in which it can be changed is if the state files a change of charge. But Your Honor I believe the court can find probable cause on the findings itself for whatever.
Well, the first line in the probable cause affidavit says the above listed defendant did commit the offense of simple battery, domestic. Yeah. I do find probable cause for.
I'm not objecting, Judge. I think it's pretty self-evident from the affidavit.
I do find probable cause for a battery charge.
Judge, we ask that you, I'm sorry, she don't be able to find the status. We ask that you don't take out the charge, just put battery in.
Okay. I'll hear from you with regard to bond.
Judge, we're going to be asking for your honor to consider straight ROR or in the alternative release to pretrial release. He's 84 years old, been living in our community since 1973. At this time, he collects Social Security. What he was is basically a maintenance worker his whole life, worked at a hospital, and now he collects Social Security. He's a registered voter here in our community. He has a clean record. Judge, he's a veteran. He served in the United States Army from 1956 through 1958. Unfortunately, there's no one he can contact to help post his monetary bond. He doesn't have a phone and property, any way to contact anybody to help post his monetary bond. Judge, I believe as far as any sort of credit cards or debit cards or anything like that that he could use to post bond is all at his home. So, Judge, we're going to be asking for ROR pretrial, and also we're going to be asking your honor to consider signing an order to allow him to go one time with law enforcement so we can retrieve property from the residence to basically maybe try and find a hotel room or some place to live while the pendency of this case.
State, have you had any contact with the victim? No.
Your Honor, and based on Mr. Norris's age, that he has no criminal history, I don't have a problem with an ROR. If the court wants one on pretrial, that's fine. Really, my only concern here is the no contact order based on the information provided about the alleged victim.
Okay, Mr. Norris, I am going to release you on your own recognizance. I do find probable cause as to the battery charge. I'm going to order that you contact pretrial release on a standard 2-time-a-week basis. You will be permitted to go to your residence with law enforcement to retrieve any items you need. However, you are not to have any contact, direct or indirect, with the alleged victim in this case. You understand?
Yes, ma'am. And sir, this is the location of pretrial across the street.
He's required to report to pretrial release within 24 hours of his being released.
Okay. So by the time you get released today, they're going to be close. So be there tomorrow before 12 noon, sir. Okay, good luck.
Richard Leyva.
Judge, we're going to be requiring a Spanish interpreter for Mr. Leyva.
Okay.
We have one on the way, Judge.
We do? Okay.
Tomás, por favor.
So we'll put that on recall. Just let me know when the interpreter gets here, please.
Yes, Judge.
Nicholas Brian Bostick.
He's here, President Main, Judge.
Good morning, Mr. Bostick. You're charged with touch or strike battery, domestic violence. I do find probable cause for that charge. I'll hear from you, counsel.
Judge, we're going to be asking for a $1,500 bond on his behalf. My understanding is the victim and him do live apart. He lives in Fort Lauderdale with his mother. His mother's a beautician. That's who he's going to be calling to help post his monetary bond. He's currently working doing AC work. He's been doing that for about 10 years now. Judge, I'm going to ask you to sign an order allowing us to photograph Mr. Bostick's injuries that he sustained, and we're going to be asking for a $1,500 bond on his behalf.
State.
Your Honor, I was going to be requesting a $2,500 bond. Your Honor, he has a possession of cocaine conviction, 2016. From what I can tell here, Your Honor, I'm showing he has a prior failure to appear and a prior conviction in the mid-90s for domestic violence battery. There potentially, based on that prior conviction, this could be upfiled to a felony battery.
Okay, as I said, I do find probable cause as to the charge. I'm going to set bond in the amount of $2,000. Mr. Bostick, you are to have no contact, direct or indirect, with the alleged victim in this case. You understand, sir?
Yes, ma'am.
Elvis Mauricio Hernandez Pavone.
He's here present, Judge, at Maine. However, he's also going to require a Spanish interpreter.
Okay. Roger Martin.
Judge, he's approaching. He declined to serve as a public defender.
Mr. Martin, you're here this morning on a capias or a warrant that was issued by Judge McHugh. bond was set in the amount of $5,000. You're gonna need to see Judge McHugh. It looks like it's gonna be set with her.
Your Honor?
Okay.
Your Honor, this is,
I don't know.
Hang on 1 second. Just let me hear from the people that are here in the courtroom, if you can listen, okay?
thank you, Your Honor. This is from an issue summons, so it's the first time he's appearing before a judge, so
okay.
I'd be requesting that the court order a no victim contact order. I believe the clerk already has the name of the alleged victim.
Okay, so this is an issue summons case where the bond was set in the amount of $5,000. I'm gonna order that you have no contact with the alleged. Well, let me just finish for a minute, and then I'll hear from you. Okay? That you have no contact with the alleged victim in this case. You understand?
Yes, can I say something?
That means direct or indirect.
Ma'am?
Yes.
This whole thing, when this summons came about,
Sir, let me just say something before you talk, okay?
Okay, I'm sorry.
We're being recorded, so everything you say is being recorded. I don't want you to say anything about the facts of the case to me. You're simply here this morning for me to advise you what the charge is, for me to tell you that I do find probable cause for that, and that the bond was previously set in the amount of $5,000.
Completely understood. The only thing I was trying to say to you is that this is my co-parent. We're already, since this time that this happened, for the same exact charge, we've already been through court. I've already been through faces with her, and we're already set to an agreement for our daughter, custody agreement for our daughter.
Okay.
There's no more restraining orders or anything, so.
Okay,
so I still continue to see my daughter in the same manner as what the court's already provided?
I'm just ordering that you have no contact with the alleged victim in this case. Whatever other orders are in place, you certainly can comply with those, okay? So you will need to see Judge McHugh on this case, okay?
Okay.
Okay.
So my bond is still the same thing?
5,000, yes. And your bond was posted, sir.
Okay, that's what I was going to make sure of.
Yes, I'm being told it was already posted.
Okay.
Okay, all right.
Am I done then?
Yes. Bridget Marie Sorling.
North Broward Judge. It's a county ordinance case. I understand Ms. Sorling would be interested in resolving this today if possible.
It looks like to me that Ms. Sorling's on felony probation. In case number 17004950CF10A with Judge Usan.
And then it may not be in Ms. Sorling's best interest to resolve this matter this morning.
Just to let the court know, I see that her supervision began on January 26th of this year. This alleged incident occurred on March 8th of this year.
Okay.
So,
Ms. Sorling, you're here this morning on a capias for, looks like for a municipal ordinance or county ordinance charge. The bond is set in the amount of $50. I do find probable cause for that charge.
Okay.
Okay?
Yes, is there any way not to have a bond? I have no way of paying that bond. My probation officer did know about
I don't want to, don't say anything about your probation case. I just wanted to let you know today that on the county ordinance case, there's a $50 bond.
Is there any way to reduce the bond? Because there's no way my mom's in a nursing home. There's no one to post a bond for me.
It's going to stay at $50.
So
you'll need to see the judge on that charge.
Okay, when would I see the judge?
I'm not sure when you'll see the judge on that case, but somebody from the public defender's office may talk to you about your other matter, which is the probation case. Okay?
Okay.
I have next, I have Genesis Velasquez Franqui. Bond was posted. I do find probable cause. That was a capias out of my division.
Spanish interpreters.
Okay.
Your Honor, our Spanish interpreter is present.
Judge, did you call Ms. Velasquez?
Yes, but apparently bond was posted.
Oh, her bond was posted? Okay.
She here?
Good. Yeah, she's right here.
Okay, well, where are you? Main jail?
Yes.
Okay. Ms. Velasquez Franqui, You're here today on a capias that was issued by me when you failed to appear in my courtroom on May the 23rd, 2018. There's a $250 bond. I do find probable cause. My understanding is that your bond has been posted. So I will see you another day in my courtroom.
Now, Judge,
Looks like,
just for
June
clarification,
7th,
The
Judge.
docket says June 7th.
Right, but that's
Is that-
because she's in custody. I'm
Right,
not sure
so that's
whether,
gonna be deleted.
I'm not
Could be
sure,
taken off.
they usually take those off, so she needs to be in figure out when her
Thank you,
next
Judge.
court date is, okay? How about Elvis Mauricio Hernandez Pavon?
He's here present, Judge, is that?
I have a Spanish interpreter,
Spanish
please.
interpreter.
Good morning. If you would, raise your right hand, sir. You swear to translate from English to Spanish and Spanish to English the best of your ability. I do. Thank you for being here this morning. Mr. Elvis Mauricio Hernandez Pavon.
Elvis Mauricio Hernández Pavón.
You're here this morning charged with touch or strike battery domestic violence.
Usted está acá esta mañana acusado de lesiones por golpe o toque por violencia doméstica.
And I do find probable cause
Considero que existe indicios probables de delito.
for that offense. I'll hear from you, counsel. There is somebody here
Señor
present in the
abogado, hay
courtroom.
alguien acá presente.
If you could, ma'am, raise your right hand.
Señora, por favor, levante su mano derecha.
You swear or affirm
Jura o afirma solemnemente
to tell me the truth.
decir la verdad. Contesta en español. Yes.
You can put your hand down.
Puede bajar la mano.
Would you state your full legal name?
Diga su nombre completo, por favor. Stephanie Ruiz Caraballo.
And how are you related to Mr. Hernandez
¿Cuál es
Pavón?
su relación con el señor Hernández Pavón? He's my husband.
Okay. What do you want to tell me about this situation?
¿Qué desea decirme sobre la situación?
Hang on a second. I don't want to do that.
That I was the one who started arguing and that I hit him first.
Okay. Do you all live together?
Ustedes conviven juntos. Yes, we have 2 daughters.
Okay, I'll hear from you, counsel.
Señor abogado, fiscal.
Judge, considering what the alleged victim said, I'm gonna ask you at this time just to keep the bond that's in place. And I'd ask you, it doesn't seem like she's in fear, so I'd ask you not to impose a no contact order at this time.
Señora juez, dado lo que ha dicho la víctima, la supuesta víctima, voy a solicitar simplemente que se mantenga en pie la fianza actual y no parece estar en una situación de temor ella, así que voy a pedir que la jueza no ordene que se abstenga de contacto.
When you say keep the bond in place, it looks like this was a medical reset and there was a notation on that the $500 bond was set.
Cuando usted dice que mantener la fianza actual, creo que es que hubo un aplazamiento médico y había una nota que decía que la fianza era $500.
Your Honor, what I believe may have happened is Judge Bailey may have, upon reading it, the report.
Su señoría, creo que lo que sucedió es que cuando el juez Bailey leyó el informe,
made a note of the intention to set a $500 bond.
hizo una nota que lo que hacía era reflejar su intención de poner una fianza de $500.
But I don't believe it was ever imposed.
Pero no creo que se haya impuesto.
Okay.
Because it was a medical reset.
What do you have on priors?
Your Honor, I do have some concern.
¿Cómo está de antecedentes? Su señoría, yo sí tengo algunas preocupaciones.
Mr. Hernandez Pavón was arrested for domestic violence, battery, and criminal mischief.
El señor Hernández Pavón fue arrestado por violencia doméstica y destrucción de la propiedad
Against the same alleged victim in 2015.
en contra de la misma supuesta víctima en el 2015.
Those charges were dropped.
Y esos cargos fueron retirados.
In 2016,
En el 2016
he was arrested for violating the no contact order in that case.
fue
That's
arrestado por
obviously the
violar
same
una
alleged victim.
orden de abstenerse de contacto en ese caso.
He ended up pleading that case out and received a year of
Y
probation
en
from
ese
Judge
caso
McHugh.
se acogió a un acuerdo y recibió 1 año de libertad condicional.
Is he currently on probation?
¿Se encuentra bajo libertad condicional actualmente?
No, it would appear his probation ended September of last year.
No, pareciera que su libertad condicional terminó en septiembre del año pasado.
Judge, my understanding is he successfully completed probation. I believe Judge Bailey didn't have the benefit of hearing from the victim herself today, in which she's basically saying that maybe Hernandez shouldn't have been arrested on this, considering it may have been, from what the victim said, self-defense. Having said that, I feel $500 is reasonable.
Señora juez, creo que el juez Bailey posiblemente no tuvo el beneficio de escuchar a la víctima y dado lo que ella está diciendo, que bajo las circunstancias pareciera que al posiblemente fue simplemente defensa propia, creo que no procedería ninguna otra medida. Sin embargo, habiendo dicho eso, yo creo que $500 de fianza es un monto razonable.
Okay, I do find probable cause. I'm going to set bond in the amount of $1,500.
Considero que existen indicios
I'm going to order
probables
no
de delito.
contact with Ms. Caraballo
Voy a imponer una fianza de $1,500
until further
y
order
voy
of
a
the
ordenar
court.
que se mantenga, abstenga de tener contacto con la señora Caraballo hasta que se disponga lo contrario.
That is either direct or indirect.
Y estoy hablando de contacto directo o indirecto.
Understand, Mr. Hernandez Pavon?
¿Entendido, señor Hernández Pavón?
¿Entiendes?
Pardon?
I don't understand what she said.
I said I set bond in the amount of $1,500,
Dije que estoy imponiendo una fianza por el monto de $1,500
and you are to have no contact
y se le prohíbe tener contacto,
whatsoever
contacto alguno,
with Ms. Caraballo
con la señora Caraballo
until further order of the court.
hasta que se disponga lo contrario.
You understand?
¿Entiende?
Yes, sí.
Okay. Okay,
Bien.
thank you. We have one more interpreter case we need.
Mr. Richard Leba, Judge, on page 3.
On page, yes. Richard Leva, good morning.
Buenos días.
You're here this morning charged with touch or strike, battery, domestic violence.
Usted está acá hoy acusado de lesiones por violencia doméstica mediante un toque o golpe.
You understand?
¿Entiende?
Sí, entiendo.
I do find probable cause as to that charge.
Considero que existen indicios probables de delito con respecto a ese cargo.
I'll hear from you, counsel.
Señor abogado.
Judge, we're going to be requesting a $1,000 bond. My understanding, this is his first arrest. He's 31 years old. If the court orders no contact, he will be living separate and apart from the alleged victim. He has family who reside in Dade County, and that's where he's going to be living. So that's the nature of why we're requesting a $1,000 bond.
Señora juez, vamos a solicitar una fianza de $1,000. Este es su primer arresto. El individuo tiene 31 años de edad. Si la señora juez ordena abstenerse de contacto, él tiene parientes en la zona de Miami-Dade, estaría viviendo con ellos, aparte de la supuesta víctima.
State.
Your Honor, he has no history.
Su señoría no tiene antecedentes.
However, when setting appropriate bond, I would just ask the court to take into consideration
Sin embargo, a la hora de fijar una fianza apropiada, solicitaría que su señoría tome en cuenta
there are 2 allegations of battery in this case.
que hay 2 acusaciones de lesiones en este caso.
One against his significant other,
Una en contra de su
his
pareja,
girlfriend, and then against her 17-year-old daughter when she was trying to get him off of her mother.
y otra en contra de la hija de 17 años de su pareja cuando ésta intentó quitar al individuo que se había abalanzado sobre la madre.
It does appear, however, Judge,
Sin embargo, señora juez, sí pareciera ser
that the first allegation is grabbing her under the arms and lifting her up.
que la primera acusación en lo que consiste es de tomarla por debajo de los brazos y alzarla.
And the allegation against the daughter is shoving her onto the bed.
Y la acusación en cuanto a la hija es que la empujó hacia la cama.
There was no punching or slapping or striking
No
or hitting.
hubo puñetazos, ni tampoco cachetadas, ni nada por el estilo.
Okay, I do find probable cause. I'm going to set bond in the amount of $1,000.
Considero que existen indicios probables
I'm also
de
going to
delito. Voy a
order
fijar una fianza de $1,000
Mr. Leva
y voy a ordenarle al señor Leiva
that you have no contact
que se abstenga de contacto
with either the alleged victim in this case
con ya sea la supuesta víctima en este caso
or her daughter.
o su hija.
You understand?
¿Entiende? Yes.
No contact means direct or indirect.
Y abstenerse de contacto significa que no puede tener contacto ni directo ni indirecto.
You understand what that means?
¿Entiende lo que significa eso? With her?
With no contact, direct or indirect, means you can't ask anybody else to contact them.
No
You
puede
can't
tener
contact them.
contacto ni directo ni indirecto. Significa que usted no le puede pedir a ninguna tercera persona que le hable a ella por usted.
Through a third party.
Contactarla mediante terceros.
You understand?
¿Entiende? Yes.
Okay.
Bien.
Thank you very much. Is there anybody else that's going to need the services of an interpreter that you know of?
Let me inquire right now, Judge.
Okay.
Your Honor, Paul Ryan needs an interpreter.
Okay. All right. Is it the next case?
Yes,
No, it says here at Main Judge requires a Spanish interpreter.
All right, thank you. We're going to go to Paul Ryan. Is this Merlin Marisol Cruz Zuniga?
What's your name?
Merlin Marisol Cruz Zuniga.
Sí.
Yes.
Okay, you're here this morning. You're charged with operating without a valid driver's license.
Usted está acá acusada de operar un vehículo automotor sin licencia válida.
Sí.
I do find probable cause as to that.
Considero que existen indicios probables de delito.
Bond is set in the amount of $25.
La fianza queda fijada en el monto de $25.
As a condition of your bond,
Como condición de su fianza,
you are...
Your Honor, there's a lot of noise.
What?
If they could turn their mic off, it may.
Can you turn the mic off? In the main jail?
There you go.
Thank you.
Could you repeat the last thing?
Miss Cruz,
Señora Cruz,
as a condition of your bond,
como condición de su fianza,
you are not to drive a vehicle.
se le prohíbe conducir un vehículo.
You understand?
¿Entiende?
Sí.
Yes.
If you are violating that, that will be a violation of your bond condition.
Si usted viola esa orden, eso constituiría una violación de las condiciones de su fianza.
You understand?
¿Entiende?
Sí.
Yes.
Okay. Okay. Anybody else? Anybody else need the services of an interpreter that anybody knows of? Okay. Thank you very much. Appreciate your help. Mr. McLawrence, can I help you?
Yes, Your Honor. Good morning.
Good morning.
Judge, I have two municipal ordinance cases out of the city of Fort Lauderdale on the court's docket. The first is Lee Luoma. He's over in the main jail. He's on page 12, Judge.
Okay.
And I included the notice to appear with the appointment order, Your Honor, so if the court wants to review that.
Lee Luoma. Lee Luoma at the main jail.
Stepped out to the restroom, Judge. He was sitting right there.
Okay. Okay, the next one is Levanta Smalls.
He's over in North Broward, Judge. He's on page 13 of the docket.
You said North Broward?
Yes, Judge.
Levanta Jamar Smalls. Good morning.
Yes, ma'am. Good morning.
You're here this morning charged with a municipal ordinance violation. It's, I do find probable cause for that violation, and there's a $25 bond set. Mr. McLawrence is here. What says you, Mr. McLawrence?
Judge, I spoke to Mr. Smalls earlier today. He told me that he actually is employed. He works doing day labor up in Riviera Beach. He's 24 years old. Normally, we don't see people arrested on these charges. Usually get a notice to appear, but in any event, Judge, Mr. Smalls indicated that he would like to resolve this matter.
State? Oh, it's a city ordinance?
Yes, Judge.
Is there nobody here from the city?
No, Judge, but you, I think it's Florida Rule of Criminal Procedure 3.170 allows you to resolve it.
Oh, I know I have authorization to resolve it. I just don't know whether the city has a position and whether there's, they would give me a position with regard to whether he has any priors.
Your Honor, if you want, as a friend of the court, I can let you know if there are
Okay,
priors.
you could do that as a friend of the court.
I'm sorry, what's his last name again?
Smalls, first name is Levanta, Levanta.
I have that here.
Yes, it is.
Your Honor, I'm showing 2017 resisting without violence, disorderly conduct at a Riviera Beach, disorderly intoxication out of Fort Lauderdale in 2017, trespass Fort Lauderdale 2017, resisting without violence, loitering and prowling Fort Lauderdale 2016, misdemeanor possession of cannabis 2014, possession of clonazepam 2013, end of record.
And how many days has Mr. Smalls been in?
He would have been arrested yesterday, I believe, Judge.
Okay. I find probable cause. I'm going to leave bond set in the amount of $25. He can see the judge who the case is before. I'll sign the order appointing you, Mr. McLawrence.
That's it, Mr. Smalls. He'll be back. Thank you.
Okay, the other one was in the main jail.
Yes, Judge. I see Mr. Luoma now.
Mr. Luoma. Mr. Luoma, you're here this morning. You're charged with a municipal ordinance violation. It looks like there was a capias on that, and bond is set in the amount of $50. I do find probable cause as to that. Mr. McLawrence is present here in court. I will sign an order appointing Mr. McLawrence to represent you on this case. As a friend of the court, is he interested in resolving this as well?
Yes, Judge, he is. I wanted to tell the court a little bit more. Judge, the Broward Sheriff's Office, Henderson, and Judge Malika had set up they coordinate to help people like Mr. Luoma who are homeless to try to get them over to Henderson and try to get them services that they need to get them off the streets. I discussed that with Mr. Luoma, and he indicated to me that that's something he'd be interested in doing. We have an order here that we use in magistrate's court to make that happen. So if the court is inclined to resolve this case here today, I'll present the court with that order. And basically, just so the court knows what happens is Henderson actually comes and picks a person up from the jail, brings them over there, evaluates them, see what their needs are, and tries to provide help.
Is that something Mr. Luoma wants to do?
That is something he said he wants to do.
Mr. Luoma?
Yes.
Mr. McLawrence is here on your behalf. He's indicating to me that you'd like to resolve this case and you'd like to avail yourselves of the services of the Henderson Clinic and some other people that might be of assistance to you. Is that something you'd like to do?
Yes, ma'am.
Judge, I have an order to that effect. May I
Okay. I do. Mr. Luoma, you want to raise your right hand? You swear or affirm to tell me the truth?
Yes.
Okay, you're charged, as I said, you're charged with a municipal ordinance violation. You understand you don't have to enter a plea to that charge if you don't want to.
Okay.
You're charged with an alcoholic beverage violation. You have an attorney here representing you. It's my understanding you'd like to enter a plea to that charge. Is that what you want to do?
Yes, ma'am.
Okay, you'd like to plead guilty or no contest?
No contest.
I'll accept your plea of no contest. I'll sentence you to time served on this case. I'm also going to sign an order directing that you be transported over to Henderson upon your release, okay? Good luck to you, sir.
Yes, sir.
Good luck to
Thank
you.
you.
Sorry? Court cost, yes. Sorry. Beatrice Wise? Anyone know where Beatrice Wise is? Beatrice Wise.
Your Honor?
Yes.
I'm showing,
Medical loan, Your Honor.
Your Honor, I'm gonna ask at this point, she was arrested on May 29th.
Yes.
I'm gonna be asking for an ROR at this point, and the reason I'm asking, Your Honor, is because she's on loan, we're paying to have a BSO deputy outside her room 24 hours a day on a drug paraphernalia, and it seems to be a waste of resources on a charge like this, Your Honor.
Okay. I have read the probable cause affidavit, and I do find probable cause. I'm going to release her on her own recognizance.
Thank you, Judge.
Yamia Cordovi?
North Broward Medical Reset, Your Honor.
Okay. And again, a medical reset?
Yes, ma'am.
Sonia Denise King.
North Broward, Your Honor.
Good morning. Ms. King, you're here charged with disorderly conduct, also charged with resisting an officer without violence and resisting or obstructing an officer with violence. I do find probable cause as to each of those offenses. Mr. Reedy, I'll hear from you.
Well, Your Honor, I spoke with Ms. King, and she indicated to me she's been living here for the last 30 years. She does have family here, including her mother. She indicated to me also that there is not an awful lot of money available for her to post bond. She does not have a stable residence at this point, but she can provide us with her mother's address, and she indicated to me that she would be staying with her mother. But unfortunately, she doesn't have her mom's phone number, so I couldn't call her mom to verify that. I'd ask the court to consider a pretrial release, ROR, put her mother's address on the record as her address of record, and allow her to go home and live with her mom until her court date comes up.
State.
I don't have on my system, do you have prior failures to appear? No prior failures to appear?
The risk assessment says high, though.
She has a lengthy history, Your Honor.
Okay. Okay.
And so the court's aware, from what I can tell, her history, it's, for the most part, possessions of cocaine. There was a strong arm robbery in 2002 that she went to prison on.
Okay, I do find probable cause as to the resisting an officer with violence. I'm going to set bond in the amount of $2,500.
Absolutely no way Ms. King is going to be able to make that bond. So she will remain in custody on an incident that, not to minimize it.
No, I don't minimize it. I've read the probable cause affidavit.
Okay, I understand. And we will be taking an eye on Ms. King.
Okay. Tatanesia Brown. North Broward. Good morning, Miss Brown.
Good morning.
Miss Brown, you're here this morning charged with grand theft, possession of cannabis, leaving the scene of a crash, and operating without a valid license. You're also here on a probation violation. You're being held no bond On the violation of probation, there's a $1,000 bond set on the grand theft. I do find probable cause. You need to see, it looks like you have a date of June the 6th regarding your violation of probation case.
And I will call your brother for you, Ms. Brown.
Victoria Machado.
Judge bonded?
Oh, it's Idania Victoria, sorry.
Bonded either way.
Bonded already?
Machado bonded.
Okay.
Yes,
As to that, I do find probable cause as to grand theft, and bond was set in the amount of $1,000. Hannah Joy Albin.
North Broward.
Miss Albin, good morning. You're here this morning charged with possession of oxycodone, driving on a suspended driver's license, and 3 separate capiases on 3 separate criminal traffic offenses. Looks like you are scheduled to see, is that Division MM?
Yes.
That's me. On June the 7th at 10 o'clock. Bond, I do find probable cause. Bond is set in the amount of $1,000 on the possession of oxycodone, $750 on the driving on a suspended third or subsequent offense, and each of the capiases have a bond in the amount of $250. As I said, you're scheduled to see me on June the 7th at 10 o'clock.
She's actually seeing you right now, Judge, and she'd like to see if the possibility of resolving some of these matters here this morning. If we could resolve some of the outstanding traffic citations, she'd be interested in being placed on pretrial release on the felony charge.
If she pled to the 3 driving on a suspended license charges, it would result in a 5-year revocation of her driver's license. I'm not prepared to accept that plea here this morning. So I'm going to see her on June the 7th at 10 o'clock.
All right. I will call Richard, Hannah.
Thank you.
Okay.
Thanks.
Nancy Allen Stillings.
She's here present at main, Judge, and she is approaching.
Good morning, Ms. Stillings. You're here this morning charged with battery on a law enforcement officer. Also charged with driving under the influence. I do find probable cause as to each of those offenses. Counsel, I'll hear from you.
Judge, we're going to be asking for Ms. Stillings to be either released on her own recognizance or released in alternative to pretrial release. My understanding, she's 72 years old. She's been residing in our community for over 50 years now. She is a registered voter. She collects Social Security. In speaking to her, she is looking forward to her day in court. She's denying the allegations. She's telling me that she was defending herself, and we're going to be asking you, touching on that subject, to sign an order allowing us to photograph the injury that she sustained. She lives in Davie. She's been residing in the same residence for the past 27 years. At this time, Judge, I believe asking for pretrial release is reasonable under the circumstances.
I don't have a problem with pretrial release supervision, Your Honor. I would ask for condition no alcohol or intoxicants.
Okay, I'm going to release her on, you're okay with an ROR on the DUI charge?
Your Honor, I'm fine. She doesn't have any prior DUIs. Her only prior was a grand theft from 1980. So with the condition no alcohol or intoxicants with pretrial supervision, I'm satisfied.
Okay, I am going to find probable cause as to each of those offenses. I'm going to release her on her own recognizance to pretrial release. She is going to be required to submit to random testing with pretrial release. She is not permitted to consume any alcohol or other intoxicants while she's on this release status. You understand, Ms. Stillings?
I do.
Pretrial release will be standard 2 times a week. And I will sign an order allowing you to take photographs.
Yes, Judge, and also a phone order as well.
Okay. Do you have those orders here?
I'll take care of it, Judge.
Okay.
And our Creole interpreter is present.
Okay. And who do we need the Creole interpreter on?
I'm not certain. I'm sure the main jail can advise us.
Can you help us in the main jail on who we might need a Creole interpreter for?
Yes, Judge. The gentleman is on page 10, and his name is Mr. Shadner St. Dor. Come on up, Mr. St. Dor.
If you could come up, sir.
Judge, he speaks English, but he feels more comfortable in Creole because that's his native language. So
Okay,
we just wanted to understand everything what's going on.
We have an interpreter here. So if you would, sir, would you raise your right hand? Do you swear to translate from English to Creole and Creole to English the best of your ability?
I do.
Thank you. If you just state your name for us.
Pierre George, certified Creole interpreter.
Thank you for being here this morning. Mr. St. Dor,
Monsieur Saint-Dor,
you're here this morning
raison là matin, hein?
charged with leaving the scene
Can
of
the
a...
interpreter speak up a little bit, Judge?
Into that mic, if you wouldn't mind. Sir, you're here charged with leaving the scene of a crash involving damage to property.
So donc, ou là parce que ou t'es sauvé après un accident qui t'est bien résultat dommage à propriété en monde.
You're also charged with 3 separate counts of driving under the influence.
Et ou gen 3 autres accusations d'est-ce que ou t'es conduit en bas influence tafia.
Also here on 3 separate traffic offenses, criminal traffic offenses,
Et ou t'es là sous 3 autres offenses trafic, infraction.
where you failed to appear,
Côté ou t'es ou pas paraître.
and the judge issued a capias or warrant.
Et juste là lui-même il était envoyé un mandat pour yo kembe.
I do find probable cause as to each of those offenses.
Juge la joindre que gen bon jan région pour tous les 3 offenses ça yo.
I will hear from you, counsel.
Et qu'on y a nous pas attendre nan men avocat pour l'état.
Judge, at this time, we're not going to ask for any modification of the bonds. We're just going to ask that Your Honor sign a property order allowing Mr. St. Dor access to his wallet so he can get a phone number out to contact his family to bond him out.
So donc qu'on y a là nous pas demander pour aucune bonne, mais n'a demandé que ou ba permission pour monsieur est capable chercher bagalio pour le contacter famille.
And I'll hear from the state.
Et qu'on y a là avocat pour l'état après parler.
I'm not requesting any modification to the bonds, Judge. I'm just asking that no alcohol or intoxicants be a condition of release.
So donc nous pas demander pour aucune autre modification par rapport avec bonne, mais c'est juste pour lui pas servir avec ta fia si tu as la gueule.
Okay, Mr. Dor, the bond amounts are as follows. A $500 bond, a $1,000 bond, a $1,000 bond, and a $1,000 bond. So the total bond is $3,500.
So donc quantité bonne là c'est $500 bonne, après ça l'autre là c'est $1,000 bonne, $1,000 bonne, $1,000 bonne qui vient avec un total de 3,500 bonnes.
I am going to order that you also report to pretrial release.
Et donc on a demandé que ou rapporter by service avant tribunal après yo fin la guerre.
You're required to call in 2 times per week.
Et on a demandé pour ouvrir l'autre boîte 2 fois par semaine.
And you're not to consume any alcohol
Et ou pas gen droit prendre aucun tafia du tout.
or other intoxicants
Ou soit aucune autre drogue dans le système.
while you're on bond. Do you understand?
Là yo la guerre sous bonne. Est-ce que vous comprenez ça, monsieur?
Oui.
Yes.
Yes. Yes.
Donc, yo demandé est-ce que y a pas monsieur supervision l'État?
That means when you post your bond, Mr. Dor,
So donc monsieur do les yo ba encore là ou ba encore bonne nan
within 24 hours of your release,
dans l'espace de 24 heures temps après yo fin la guerre,
you're going to be required
l'État a demandé
to report to
pour le rapporter
pretrial release.
dans service l'État yo relé en vent tribunal pour dans liberté provisoire.
You understand that?
Est-ce que vous comprenez ça, monsieur? Yes.
You'll be subject to random testing.
Et yo capable de tester au bout de secours sans attendre.
Qui ça?
Yo capable
Random.
de tester au sans attendre.
Qui ça?
Counts 2, 3, and 4.
So donc sous accusation 2, 3 et 4, yo capable de tester sans pour voir si vous n'avez aucun bagage dans le système sans attendre.
Okay.
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 Since it's a
No,
criminal
just count 2, 3, and 4.
Thank you.
Okay. You understand, sir?
Donc, est-ce que vous comprenez ça, monsieur?
Oui, je comprends ce que dire.
Yes, I understand what you're saying.
Okay.
Ok, d'accord.
Anybody else need the services of a Creole interpreter while we're here?
Est-ce qu'il y a d'autres gens qui ont besoin de service yon interprète créole pendant nous là?
Nobody else here at Main, Judge.
Thank you very much for helping this morning.
My pleasure.
Appreciate it. Martine Augustine? You know where Miss Augustine is?
She is here present, Judge, at Main.
Okay. Good morning.
Good morning.
Charged with possession of cocaine and driving with a suspended license without knowledge. You do find probable cause as to that charge, and I'll hear from you, counsel.
Judge, we're going to be asking Ms. Augustine to be released on ROR or to pretrial release. She's 42 years old, been residing in South Florida her whole entire life. She's working right now. She works for United Healthcare, where she's an enrollment specialist. Unfortunately, she's from what she advised me, she's been a victim of domestic violence, which has led her to lose her home, and at this time she is homeless. Judge, she is a registered voter here in Broward County. She does have a mailing address, so a P.O. box. Right now, she has no one to really contact to help post her bond. Her son is serving in the United States Army, and he is overseas. So therefore, considering this is a nonviolent offense, Judge, we'd be asking you for an ROR and the alternative release to pretrial release, Judge.
State.
I have no objection to pretrial, Your Honor.
Okay, I do notice that she has another case with Judge Solomon where she just recently updated her address to a P.O. box, so we are going to need an updated address in order to get her notice, because there was a previous capias in that case where she failed to appear. So do you have an address that you can give us where she can get notice?
It's the P.O. box she's advising me, Judge. What is it?
It's P.O. Box 190324.
Say it.
324.
190324.
Fort Lauderdale, Florida.
Fort Lauderdale, Florida.
33319.
33319. Judge, from what she advised me, her P.O. box number is 190324. That's in Fort Lauderdale, Florida, and the zip code she's informing me of is 33319.
Mr. Reedy, I don't know, since I'm only here today and not here on a regular basis, I note just as a routine in my division that a lot of times who's ever here in magistrates will put the change of address on this form and ask that it be changed, but that doesn't cause the clerk to update it. So I don't know if you all have a change of address form here.
We do not. Generally, what Judge Malika does is she advises the clerk. She actually, I think, changes it on the
I'm doing it too, but
herself.
it doesn't happen because that's not an order to the clerk. And so they don't see it and they don't do it.
I don't know. I'm not accustomed to filling out change of address orders. I'd be more than happy to do it. We do not have a regular form for that.
Okay. Ms. Augustine, I'm going to release you on your own recognizance. I am going to order that you be supervised by pretrial release, which means when you are released, you're going to need to make contact with pretrial release within 24 hours. And you're going to be required to report to them 2 times per week by calling in. You understand?
Yes, ma'am.
Thank you, Judge. Okay, this is the address of the pretrial. Most likely you're going to be released today after 4.
She should report immediately in person
so you have to go
upon
there
release.
before 12 noon tomorrow. You just walk across the street, okay? Good luck, man.
All right, thank you.
Oh.
Rory Dixon.
Mr. Dixon, come on up, please. He's here present, Judge.
Good morning, Mr. Dixon. You're charged with trespass, failing to leave property upon order by the owner. Bond is set in the amount of $25. I will hear from you, counsel.
Judge, Mr. Dixon did advise me at this time that financially he can't make that bond. Considering this is a misdemeanor offense, Judge, we're going to be asking for a straight ROR on Mr. Dixon's behalf.
Problem is, he's got an at-large address, counsel.
Judge, from what Mr. Dixon has advised me, that is correct, and unfortunately, he doesn't have a mailing address. However, Judge, just because financially he's indigent, he doesn't have a residence, I don't think that precludes the court from ordering an ROR. It would be his prerogative, his responsibility to either, he signed up with the public defender's office, he can contact us to find out future court dates, or he can go online. I know Broward County Library has computers where he can access them free of charge and look him up and go on clerk of court's website and see his own future court dates. So, Judge, I still ask you, considering his financial status and what the charges primarily of trespass, I'd ask you for an ROR.
State, do you have any priors?
Yes, Your Honor. He actually resolved a trespass before you last December, and that also involves someone's home, as does this case.
Okay, I'm going to leave the bond at $25. I do find probable cause.
And, Your Honor, I apologize if you already ordered it, but I would just be asking no return to this listed residence.
Yeah, Mr. Dixon, you're not to return to the location where this incident occurred, and you're to have no contact with the alleged victim in this case. You understand, sir?
Yes.
Okay. Harold Beresford Cockett.
He's approaching, Judge.
Hi, good morning, Mr. Cockett. You're charged with driving under the influence. I do find probable cause for that offense. Counsel?
Judge, we're going to be asking for the court to consider releasing Mr. Cockett on pretrial release. Right now, he's living in Hollywood. He's been living at the same residence for about 1 year. His monthly rent is about $800. He's 58 years old, been living here his whole entire life. He has his own business. It's a car detailing and pressure washing mobile business. So he goes around with his clients to service them. So, Judge, we'd be asking, right now there's nobody, he informed me, that can post his monetary bond, and that is the basis of why we're asking for pretrial release on his behalf, Judge.
State?
Requesting the $500 bond be kept in place. He's got a 2013 burglary of an occupied dwelling, 2000 grand theft 99, 2 counts burglary conveyance 99. And with whatever bond or release your honor sets, we'd also be asking condition no alcohol or intoxicants.
I'm looking at Mr. Cockett's driving record as well. I'm going to leave bond in the amount of $500 as a condition of his bond. He's not to consume any alcohol or other intoxicants. It goes without saying he's not permitted to drive until he has a valid driver's license.
Judge, what we're going to be asking, considering he's being placed now on pretrial with supervision, right now he's not
being placed on supervision. The bond is set in the amount of $500. As a condition of that bond, I'm ordering that he not consume any alcohol.
Yes, Judge.
Okay.
Judge, he wants to talk to the court.
Ma'am, I have no money and I have no relatives here. I need to drive my truck to make the money to pay whatever the court can do.
Guess what, Mr. Cockett? You cannot drive a vehicle until you have a valid driver's license.
I understand, but I can't get out to make the money if the bond is at $500.
I understand, sir. Your bond is $500. Your bond is.
I don't have the money.
I understand, sir. I've read the probable cause.
I'm gonna have to sit in here. My rent is gonna be due. My truck is at the towing company. Everything is gonna pile on me, and I'm trying to make another life besides my past priors.
Okay.
So please give me a chance to live.
You have the ability to communicate with the public defender's office, and they can assist you in any way they can in trying to resolve this case. But right now, your bond's set in the amount of $500.
And I can't get the $500. So I'll be sitting here. My rent's gonna be due. My rent is due on the 3rd. That's another $200-300 piling up on me because I can't have access to my machines on my truck. Please, ma'am, give me some time to live, get out, get my truck back on the road. I will pay whatever it is, but the only way I'm going to survive this is to be out and pay my rent because it's due on the 3rd.
I understand, sir. I understand, sir. You need to talk to your attorney. I've found probable cause and the bond is set at $500. Albert Coe Mears.
Mr. Mears, is here Judge Maine?
Yes, ma'am.
Mr. Mears is charged with trespass, failing to leave property upon order by the owner. I do find probable cause. I'll hear from you, counsel.
Judge, he wishes to ask the court if the court would consider resolving his case today for time served.
I'm not inclined to do that based on the probable cause affidavit in this case. His bond is set in the amount of $25. Have you had any contact with the victims?
No, Your Honor. If you want to put it on recall, I can make a call.
Okay. If you want to put it on recall, we can. And you can make a call. It looks like the trespass involves family members.
Yes, Your Honor.
So, you want us to put it on recall?
Judge, in the alternative, if Your Honor would consider releasing Mr. Mears' ROR, I do understand that while the pendency of this case, he will have a separate place to live. So I don't know if Your Honor would consider an ROR on Mr. Mears' behalf.
I'm not going to do that at this point. If you want me to put it on recall, states indicated they would reach out and make contact with the alleged victims in this case. Would you like us to do that or not?
Yeah.
Okay.
Yes, please.
We'll put it on recall. Jean Rittel Alti.
Mr. Alti, Jean is here present, Judge?
Hi, good morning. Is it Mr. Alti?
Good morning, Your Honor.
You're here this morning charged with driving on a suspended driver's license, as well as 2 separate out-of-county holds. I do find probable cause for the driving on a suspended driver's license charge. The other county, it looks like Lee County, and the bond on those is $7,500 on each of them. Okay, so the bond in this case is $100, and the bond on the other 2 county holds is $7,500 each. Okay?
Judge, I'm going to ask you on count 1 to consider an ROR so then that Lee County can come and pick him up.
Well, he needs to deal with the driving on a suspended license, so I'm going to leave it as it is for now. Orlando Don Henry.
Mr. Alti has advised me he wishes to address the court.
Okay.
Your Honor, when I
Don't say, listen, I just want you to understand something before you talk to me. I'm happy to hear from you, but anything you say is being recorded.
Yeah,
you understand? Okay, and you have an attorney. You have an attorney standing right next to you, who's willing to represent you and assist you. So, what is it you'd like to say?
Well, what I would like to say is, when I had those charges, like I didn't have a job and I was homeless. Now I recently have a job and I'm working and I pay our apartment for me to stay. If I don't get out of here, I was supposed to be at work this morning. If I don't get out of here, I won't be able to go to work. And when I come out of here at any time, my rent is due. I'm gonna be homeless again.
I understand, and I would be able to assist you, except for the fact that the charges that the bond are set on are from another county. So I can't change those bonds. Those are for, you need to see a judge in Lee County to address.
So, and how long are they gonna have to come pick me up, if anything?
Why don't you talk to the attorney right there? Maybe he can give you some information about that.
Oh, I did already.
Okay.
He didn't know.
Okay.
Your Honor?
Yes.
And whenever you want, we can go back to Mr. Mears' case.
Okay. Let's recall Mr. Mears. Albert Coe Mears.
Your Honor, I just got off the phone with Mr. Mears' father. He has advised me, I do not have an offer at this time. He's advised me that Previously, Mr. Mears has gone onto the property, damaged property. He would want to address the court on a future date if this case were to be resolved, so.
Okay, so Mr. Mears, I found probable cause and the bond in your case is $25. Orlando Don Henry.
Come on up, Mr. Henry.
Hey, guys.
Mr. Henry's here this morning. Good morning, Mr. Henry. You're charged with petty theft, also charged with trespass. I do find probable cause. Bond is set. I'll hear from you, counsel, on the bond.
Judge, he's going to want to ask the court if you would consider resolving his cases today.
State.
Your Honor.
On Mr. Henry's case?
Yes, Your Honor, the state's offer would be on count 1, 10 days. He just resolved a theft May 14th of this year, another theft April 30th of this year. He has a resisting without violence that was filed April 10th and may still be pending. I count 1, 2, 3 other trespasses this year, a theft from February, a theft from November of last year.
Mr. Henry, want to resolve this case? It's the state's recommendation that it's 10 days in the Broward County Jail. Yes?
He advised me he does, Judge.
Okay. Mr. Henry, want to raise your right hand, sir? You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. Would you state your full legal name for me?
Henry, Orlando.
Is your first name Orlando?
Yes.
Is your last name Henry?
Yes.
Okay, you understand what the charges are against you here this morning?
Yeah, I think it's misdemeanor.
It's a petty theft and a trespass.
It's misdemeanor, right?
Yes, 2 separate misdemeanors, petty theft and trespassing.
All right.
You had a chance to talk to the attorney standing next to you about your case?
Oh, he's the attorney? Oh, yeah, he talking.
Are you satisfied with his advice?
Oh, yes, yeah.
You understand you don't have to enter a plea here today?
Yes, ma'am.
Is that what you want to do?
I just want to resolve it.
Is anybody threatening you or coercing you or convincing you to do this?
No, I'm not hearing the voices of my ears, ma'am.
You're doing this because you believe it to be in your best interest?
Yes, ma'am.
Counsel, you satisfied with Mr. Henry understands the nature of the charge and the consequence of entering into the plea here this morning?
One moment, Judge. Judge, in speaking with Mr. Henry, he seems to understand everything what's going on, so at this time, I have no concerns.
Okay, Mr. Henry, then, how would you like to plead to petty theft and trespassing? Guilty or no contest?
No contest, ma'am.
I'll accept your plea of no contest. I'm going to sentence you to 10 days in the Broward County Jail. I'm going to give you credit for any time you have served in jail now, okay?
All right.
That's on each count to run concurrent. On count 1, there'll be $293 in court costs. Count 2, waive any additional costs. You need a minute? Brandon Sean Benchina?
He's here, President.
Is that how you say it? Benchina. Good morning, sir.
Good morning.
Here on 2 separate capiases. Looks like criminal traffic, driving on a suspended license. One of them is a $250 bond and one of them is a $500 bond. I do find probable cause. Looks like you're going to see your judge on June the 6th at 9 o'clock in the morning.
Judge, in speaking with Mr. Bencina, he wishes to ask the court if you would consider resolving both of these matters today for time served.
State?
1 moment, Your Honor. Yeah, I have no objection. That would be the state's offer adjudication time served on both cases.
I'm looking at Mr. Bencina's driving record. It looks like this would be number 1 and 2 of driving on a suspended license charge if he wants to resolve them today. I can only tell you what's on the driving record, nothing else. I don't know if anything else is pending, counsel.
He wishes to accept the state's offer, Judge.
Okay, Mr. Bencina, would you raise your right hand, please? You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. Sir, you understand you're charged with 2 separate charges of driving on a suspended driver's license.
Yes.
And each of those looks like they're charged, are they charged as first-degree misdemeanors or? Looks like, are each of them charged as first degrees, if you know, counsel?
1 moment, Your Honor.
I only have the capias, I don't have the.
Yeah, I'm checking that right now. From what I can tell, the 2018 case
Yes,
was filed as a second degree,
okay.
and
Which would mean the 2015 would be as well,
I would
likely,
imagine.
right? Okay, Mr. Bencina, you're here, each of them is a second-degree misdemeanor, punishable by a maximum of 60 days in the Broward County Jail. You understand that?
Is that my sentence?
I said the
What is
max,
punishable
the
by-
max.
Yes, ma'am, I understand.
The attorney standing next to you, have you had a chance to talk to him?
Yes.
Are you satisfied with his advice?
What is? Yes.
You need
Yes.
you need any more time to talk to him?
No, ma'am.
You understand that each of these charges is driving on a suspended license. The Department of Motor Vehicles keeps track of these charges. If you get a combination of 3 convictions for driving on a suspended license in a 5-year period, the Department of Motor Vehicles will suspend your license for a period of 5 years. You understand that?
Yes, ma'am.
Knowing that, you still wish to enter a plea to these charges?
Yes, ma'am.
Anybody threatening you or coercing you to do that?
No, ma'am.
You're doing it because you believe it to be in your best interest.
Yes, ma'am.
You under the influence of any alcohol or drugs here this morning that would affect your ability to understand what you're doing?
No, ma'am.
How would you like to plead then, sir, to each count of driving on a suspended driver's license? Guilty or no contest?
No contest.
I'll accept your plea to each of these charges, sir. And as to count 1, driving on a suspended license on case number 1800688 TC10A, I'm going to adjudicate you guilty, impose 1 day in the Broward County Jail, credit for 1 day time served, and $293 in court costs. I'm going to give you 6 months to pay that court cost. On the second count, I'm going to adjudicate you guilty, sentence you to 1 day in the Broward County Jail, credit for 1 day time served, and order $293 in court costs. I'll give you 6 months to pay that. You understand?
Yes, ma'am.
Okay. Okay, 2 days with credit for 2 days time served. Time served is fine. Okay.
Good luck, Judge.
She has to put it in, so. Yes. Okay. 2 days, Broward County Jail, credit 2 days time served.
Okay, just say 2 days in Broward County Jail. We'll give you.
Okay. Donald Skinner.
He might be in North Broward, Judge.
Okay. Donald Skinner.
And he may wish to resolve these matters this morning.
Good morning, Mr. Skinner.
Good morning, ma'am.
Mr. Skinner, you're here on, looks like 3 separate capiases. I can't see which division it is. Do you, Judge Solomon?
Yes, ma'am.
Okay, and it looks like each of the one capias is on a trespass, one is on a petty theft, and one is on an inhaler ingest possession of a harmful chemical substance. It looks like Mr. Skinner self-surrendered and is here today on these 3 cases.
How are you feeling, Mr. Skinner?
Feeling good.
You want to resolve these matters? Would you like to resolve these matters today if possible?
Yes, yes, sir.
I'd ask the court, in light of the fact that he did self-surrender, to consider an offer of time served.
State, these are 3 separate cases with Judge Solomon?
It's 3 counts on 1 case.
Oh, it's 1 case, 3 counts? Since I don't have the benefit of the probable cause affidavit.
And Your Honor, frankly, I really don't have an offer. I reviewed the offer that was put in the system by the prosecutor assigned to the case just, looks like a week ago, and it's, frankly, it's a 30-day Broward County Jail offer. He does have priors, a theft last year, theft 2016, inhaling harmful chemical substances 2016, resisting without violence, inhaling harmful chemical substances 2016, disorderly. I'm not in a position really to undercut that ASA's offer.
Okay, Mr. Skinner, I do find probable cause. You have, as you probably are already aware, a $500 bond on each of the counts for a total of $1,500. It looks like you're going to see Judge Solomon, and you can talk to Judge Solomon about resolving your case, okay?
Okay, ma'am.
All right. Mark Anthony Willis. Where's Mr. Willis? Okay. Good morning, Mr. Willis.
Good morning.
Mr. Willis might also be interested in possibly resolving this matter, Judge.
Mr. Willis, you're here this morning charged with trespass. I do find probable cause as to that offense, and I will hear from the state with regard to that.
Your Honor, I don't see any prior cases that he's pled out, so if he wants to resolve the state's offer, be withhold court costs, judicial notice of time served, no return to the Seminole Hard Rock Hotel and Casino.
He already has a lifetime trespass at that location.
That appears to be correct, Judge. Mr. Willis, is that what you would like to do, resolve the case for the time that you've spent in jail?
Yes, please. I'd like to do that. And that's just a misunderstanding.
Maybe a misunderstanding, but you can't go back there.
Mr. Willis, if I accept a plea from you today, a condition of the plea is that you're not going to be returning ever to that location, any of the Seminole property. You understand that?
I do, yes. I didn't know I couldn't return to all of them, but now I understand exactly what that is. I'm clear.
It looks like apparently they believe there to be a lifetime trespass warning against you as to all of their properties. You understand that?
Yes, I do. Now I do, yes.
Okay. If you would, sir, raise your right hand. Do you swear or affirm to tell me the truth?
Yes.
You can put your hand down. Would you state your full legal name?
Mark Anthony Willis.
Mr. Willis, you're here this morning. Have you had an opportunity to consult with an attorney from the Public Defender's Office?
No, I haven't, but...
Do you need any more time to talk to me, Mr. Willis?
No, I don't.
Mr. Reedy is here in the courtroom, is in fact an attorney from the Public Defender's Office. Have you had a chance to consult with them?
No, I haven't.
Would you like to?
Is there anything else you want to ask me, Mr. Willis?
What's that?
Is there anything else that you would like to ask me?
The only question I just have is that if I can be released and not return back there.
That's the deal.
And am I charged with something, or is this like a withheld adjudication, or how does this work?
No, you're charged with trespass, and the offer is an adjudication of guilt if you enter a plea here today.
And the state's offers a withhold.
Oh, the state's offers a withhold?
There's no conviction on your record. You'll get out of jail today with court costs and an understanding and an agreement that you not return to any Hard Rock properties.
Any Seminole properties.
Or it's any Seminole properties.
You understand that, sir?
Yes.
Is that what you want to do?
And if I go to trial with this, I have to stay in here for the rest of the day, or I won't be able to be released?
You have a bond set in the amount of $100.
All right, let's just resolve it today.
You understand that you don't have to do that?
I have no choice.
Yes, you do have a choice, sir.
No, I'm going to resolve.
Do you live at the address in Coral Springs?
Yes, I do.
Okay, I'm going to release you on your own recognizance, sir, which means you're going to be released on your own without any monetary bond. A condition of that bond, however, is that you not return to any Seminole property. You understand?
Yes, I do.
Now, this case is still pending. What that means is that you need to find out when you're going to go to court, and you need to appear in court. You understand?
Yes, I do.
So I'm going to release you on your own recognizance today, and you will need to find out, and you should get a notice in the mail at that Coral Springs address. Is that the correct address?
9936, yes, that's correct.
All right. All right, so I do find probable cause, and I'll release him on his own recognizance. Paul Ridley.
I believe he's also a North Broward judge.
Good morning, Mr. Ridley.
Good morning.
Mr. Ridley, you're charged with resisting an officer without violence and trespass. I do find probable cause as to each of those offenses. I'll hear from you, Mr. Reedy.
I was wondering if the state had an offer on these charges.
Your Honor, state's offer would be 15 days adjudication, time served on both. He just pled out a theft and resisting a theft a couple weeks ago at a different Walmart. He pled out a few months ago for theft, resisting a merchant and criminal mischief at the same Walmart as he's before in this case. So I do have concerns what he was actually doing at this specific Walmart to begin with.
Your Honor, additionally, the defendant is on pretrial supervision in case number 18-3974-MM10A, resist, obstruct without violence. We'd be asking, based on the court's finding of probable cause, that you revoke his supervision in that case.
And what judge is that case assigned to?
That judge is Judge Levy, Your Honor.
Mr. Reedy?
In light of that, Judge, I don't think it would be in Mr. Ridley's best interest to resolve this matter this morning. I think he probably needs to go in front of Judge Levy. I'd ask you not to take any action on the outstanding pretrial release, as it is also a misdemeanor charge. And I'd ask the court to consider allowing Mr. Ridley to be released on his own recognizance. I don't believe he's in a condition to post any monetary bond. Is that right, Mr. Ridley? Do you have any money to get out of jail?
No, I don't.
Okay, I do note that on case number 1800226 MM10A, Mr. Ridley just on March 21st entered a plea before Judge Brown, was ordered not to return to this particular Walmart where this incident occurred. I do find probable cause, and as to case number 183974 MM10A, I am going to revoke his pretrial release. And he'll be held no bond on that to see Judge Levy, if we can get it for a date for Judge Levy. In this case, I'm going to set bond in the amount of $500. Mr. Ridley, you'll see Judge Levy. Kevin Lavita Jackson.
Medical reset.
Do I sign it when it's a medical reset? Oh, okay. David Emmanuel Kingsley Smith.
Mr. Kingsley Smith is here present at main, Judge.
Good morning, Mr. Kingsley Smith. You're here this morning charged with burglary of an unoccupied conveyance, unarmed, also resisting an officer with violence. I do find probable cause as to each of those offenses. Counsel.
Judge, I would like to hear the state's recommendation first.
And I'm pulling up his criminal history. He wasn't on my list, so I'm gonna
Okay.
Your Honor, I'm going to be requesting a $2,500 bond on count 1, $1,000 bond on 2, in order no victim contact.
Judge, thank you for that. And speaking of Mr. Kingsley, Judge, right now he's looking for work, so he's not employed. He has no financial resource, no money coming in. He's 20 years old. He lives in Miami Gardens with a friend of his mother who's allowing him to stay there. She's retired and elderly. She's been there for about 2 years. Right now, he believes maybe he can call someone. Maybe they can come up with through a bondsman, 10%. So we'd be asking you for a $1,000 bond on count 1 and ROR on count 2, Judge.
Okay, on count 1, I'm going to set a $1,500 bond. On count 2, I'm going to set a $2,500 bond. I do find probable cause. Javane Lance McDonald.
Mr. McDonald is approaching, Judge. He did advise me he has private counsel, Mr. Barry Whitley.
Yes, that's correct, Judge. I spoke with Mr. Whitling earlier this morning. He indicated he would not be here today. He's feel free, he said, for you to magistrate Mr. McDonald on this charge, and he wants Mr. McDonald to know that he will be out to see him very soon.
Okay, Mr. McDonald, your attorney apparently did make contact with the assistant public defender who's here present in the courtroom this morning, indicated that he would be out to see you on this case. You are charged with premeditated murder. I do find probable cause with regard to that. There was a arrest warrant issued. It does carry a no bond. It does have a no bond attached.
And Your Honor, pursuant to ESAS of the state, for first appearance purposes only, I am going to be requesting that the court make a finding of proof evident or presumption grade based on the arrest warrant affidavit seeking a no bond hold.
I do make the finding of proof evident presumption great, and I do note that the warrant that was issued does have a no bond hold.
And Your Honor, the only other release condition I'm going to ask for at this time is that there be no contact with either of the listed witnesses whose initials are NS and MH, and certainly Mr. McDonald's counsel, when he gets a copy of the affidavit, can provide those names to Mr. McDonald.
No contact with?
NS and MH.
Okay. Okay, Mr. McDonald, as a condition of any bond that's set in the future, you are not to have any contact with the individuals identified by NS and MH. You understand? Your attorney will be out to see you, sir.
Okay.
Giovanni Francisco Martinez.
Please approach, Judge.
Good morning, Mr. Martinez.
Good morning, Your Honor.
You're here this morning charged with resisting an officer without violence, fleeing and eluding a law enforcement officer with lights and sirens active, reckless driving, driving on a suspended driver's license, along with some accompanying traffic citations. I do find probable cause as to each of the offenses. I'll hear from you, counsel.
Judge, we're going to be asking for Mr. Martinez to be released on pre-trial release. Right now, unfortunately, he advised me that there's no one he can contact to help post his bond. He's 33 years old, his whole entire life. He is working, he works in construction. He's been doing that for about 1 year. He does have prior contact with the criminal justice system, but I believe it's a little bit dated. He lives in Hallandale. He just moved into his new residence. So he just moved in, I believe, about a week ago. He's renting a room, and that rent is $450 per month. He still receives mail at his prior address. So even though he doesn't have the address of his new place, he still has the prior address of his old place that his mail is going to be forwarded. So, Judge, right now, considering he has no financial resources, we'd be asking you to consider releasing him on pretrial release for count number 2.
State.
Your Honor, the state would be opposing straight our order pretrial. I do have a concern about his future appearance in court, just based not only on the nature of the offense, but that the officer had to actually physically remove his hand from the accelerator on the motorcycle to get him to continue fleeing. That I believe he drove into oncoming traffic to avoid apprehension. So I'd be requesting, actually, one moment, Your Honor. I'm asking that the set bonds be kept in place.
Okay, as I said, I do find probable cause. I'm going to leave the bond on the fleeing and eluding charge at $2,500.
Thank you, Judge.
Zachary Brooks.
He's approaching.
Good morning, Mr. Brooks. Mr. Brooks,
Good morning.
you're here this morning charged with possession of cannabis. You're also being held no bond on a violation of probation case. I do find probable cause. Bond in the cannabis case is set in the amount of $100. It looks like he has a date of June the 18th at 9 o'clock in the morning to see his judge on the violation of probation.
Thank you, Judge.
Nathaniel Keith McQueen.
Judge, I believe he was, my notes, removed per confinement status.
So he was already picked up by the U.S. Marshals?
No, he shouldn't have been on the docket at all because he's a U.S. Marshal.
It's just not usually
Okay,
a problem.
so I don't need to do anything with the paperwork. Thank you. Mark Joseph.
And
He's approaching,
if I
Judge.
may be heard before the court makes any determination.
On this one?
Yes.
Yes. And there's a co-defendant as well.
And then my request is going to apply to both, Your Honor. I don't know if maybe.
You want to bring them both up? You represent
It's
it?
up to you, Judge.
Okay, let's start with Mark Joseph by himself.
Your Honor, pursuant to the rules of criminal procedure, I'm going to ask the court to defer ruling on probable cause for 24 hours. I'd like an opportunity to bring, I've spoken to the deputy, and I'd like an opportunity to bring more information to the court tomorrow for a probable cause determination.
Counsel, do you have anything to say?
I'd like more of an explanation than that, but I do think that the state, under the rules, is entitled to a 24-hour reset.
Well, the state's indicated they'd like to bring the detective forward.
Well, no, I'm going to get a supplemental report. I spoke to the deputy and.
Okay. I'm going to grant the state's request for a 24-hour to perfect the probable cause in this case, and I'll defer.
Is that also in reference to Mr. Syriac?
Apparently, that's the same request. Yes. So I'm not going to make any finding. I'm just going to defer to, and I'm going to.
And the same objection to both.
Okay, so if I can have Alan Syriac, please.
Yes, all right, so you'll come back to it. Mr. Sherry, come on. They're asking to defer for 24 hours. That's their right, because they don't have enough information right now, so they can ask the judge. Oh, sorry.
The state is requesting 24 hours to bring forth more evidence with regard to probable cause. I'm granting the state's request. I note, counsel for the defense, I note your objection for the record. We'll reset them both for tomorrow. Mark Joseph and Alan Syriac. both reset for tomorrow.
Bless you.
Bless you. Tavares Grayhart.
Mr. Grayhart is approaching, Judge, and he declined to serve as public defender.
Good morning, Mr. Grayhart.
Good morning.
Mr. Grayhart, you're here this morning charged with robbery. Was that without?
Yeah, too strong arm.
Without a firearm or weapon. A second count of robbery without a firearm or weapon, resisting an officer without violence. And you're also here on a probation violation where there's a no bond hold. You have a date to see your judge on the violation of probation for June the 6th. It looks like at 3 o'clock in the afternoon. Okay, I do find probable cause as to the robbery charges, State.
Your Honor, I'm going to be requesting $10,000 bonds on each count. Not only based on the allegations and that he's on probation currently, but also he has a prior conviction in 2011 for strong arm robbery and a grand theft in 2014.
Okay, I do find probable cause, as I said, on count 1, robbery without a firearm. I'm going to set bond in the amount of $10,000. On count 2, is set bond in the amount of $10,000. On count 3, bond is set in the amount of $100. And on the violation of probation, you're being held no bond. You'll see your judge on June the 6th at 3 o'clock in the afternoon.
And Your Honor, I've just also asked for an order of no victim contact.
And as a condition of any release, sir, if you were to post bond on these cases, you're not to have any contact with the alleged victim in this case. You understand?
Okay.
Okay. Matthew Ryan Larson.
Mr. Larson is here present, Judge?
Okay, Mr. Larson's here charged with grand theft auto, also charged with driving while suspended license, habitual offender. I do find probable cause as to each of those. I'll hear from you, counsel.
Judge, we're going to be asking for Mr. Larson to be released on pretrial release. He's 31 years old, been here his whole life. Unfortunately, at this time, he doesn't have his phone with him, so he has no one to help post his bond because he can't contact anyone. He's living in Margate. He rents an apartment by himself. His monthly rent is about $900. He works. He's working at a place called Resort Exchange International. He's been there since February. He makes about $400 a week, and the reason, like I said, that why we're requesting pretrial is because he can't contact anybody. Now, he does have priors, but I believe they were over 2 years ago. These are nonviolent offenses, so Judge, I'm asking for him to be released on pretrial.
State?
Yeah, the state would be opposing pretrial. He has, his priors include, 1 moment. (2017) out of Palm Beach County, resisting an officer without violence, possession of marijuana with intent to sell or deliver. 2016 out of Palm Beach, paraphernalia, resisting without violence, fleeing and eluding law enforcement. From 2014 out of Palm Beach, grand theft out of Palm Beach in 2012. Judge, looks like he's violated probation previously in Palm Beach. Another grand theft from a victim over the age of 65. 2 counts, and that was in 2009 in Palm Beach.
Judge, the only information, I didn't hear. I'm sorry, Mr. Lender, if I interrupted you.
But he was done.
Oh, he's done?
Yes.
Oh. The only additional information I wish to address, I believe, Judge, the grand theft auto stems from Mr. Larson keeping I guess a car that he rented too long. So, Judge, it's a little bit different from a standard, just a grand theft auto. My understanding is when he rented his car, he provided his identification, things of that nature, Judge. He just didn't bring it back in a timely manner. I'd ask you to take that into consideration for mitigation purposes and ask you to consider releasing him on pretrial release.
And as the court's aware, I don't know if Mr. Romero had an opportunity to look at the PC, but it does appear Mr. Larson was switching the tags on the vehicle, so it certainly would appear that there was certain knowledge of the.
The allegations in the probable cause affidavit allege that there was a tag in the vehicle that was in the trunk. And so I do find probable cause, as I said. I'm going to leave the bond at $1,000 on count 1. It's $750 on count 2. Daniel Diaz.
He's approaching, Judge.
Mr. Diaz, good morning. You're charged with aggravated assault with a deadly weapon. Count 1 and 2 are aggravated assaults. Count 3 is a burglary of an unoccupied vehicle. Count 4 is a touch or strike battery. And count 5 is a resisting an officer without violence. I do find probable cause as to each of those offenses. Counsel?
Judge, unfortunately, Mr. Diaz is financially indigent. He is homeless. He has no mailing address. He is not employed. He's 52 years old. I'd ask you to take all that into consideration, determining reasonable release conditions, and also ask you to sign a photo order so we can photograph Mr. Diaz's injuries.
Stay.
Your Honor, I have concerns. First, I'd note his record. He has burglary conveyances in 2014, 2011. He violated probation in 2011. Possession of cocaine 2016, 3 more in 2016. Also noting, Your Honor, according to the report, he told officers he'll be out in 2 days. He'll be doing this again. He got caught this time, but it's just part of the game. I'm requesting $7,500 bonds on counts 1, 2, and 3. No victim contact.
Okay, as I said, I do find probable cause. As to count 1, aggravated assault with a deadly weapon, set bond in the amount of $5,000. Count 2, bond in the amount of $5,000. And count 3, burglary, set bond in the amount of $2,500. Count 4, bond is set in the amount of $1,000. And count 5, bond is set in the amount of $100. I will sign an order allowing you to take photos of Mr. Diaz.
Your Honor, as far as no victim contact?
And Mr. Diaz is to have no contact with any of the alleged victims. That includes the victims of the burglary and or the officers involved. Carrie O'Neill Rice.
He's approaching, Judge.
Mr. Rice, you're charged with burglary of an unoccupied conveyance, unarmed, operating without a valid driver's license, and burglary of an unoccupied conveyance, unarmed. I do find probable cause as to each of those offenses. Counsel.
Judge, we're going to be asking for a $1,000 bond on count 1, $1,000 bond on count 3. He's 25 years old. At this time, he's unemployed, but looking for work. He last worked at a place called Global Warehouse where he was making about $10 an hour. He's going to contact the mother of this child, and what she does for a living, she's a housekeeper. So financially, her financial resources are quite limited. He believes that maybe through a bondsman she can come up with the premium. That's the reason why we're asking for $1,000 on 1, $1,000 on 3.
Your Honor, I'm going to be requesting bonds in the amount of $7,500 on 1 and 3. Also, depending on what actions the court takes, I'd be requesting a GPS monitor. However, I'll wait and see.
You have any priors?
Your Honor, Mr. Rice was arrested on May 17th of this year and is currently out on bond, $1,000 bond for grand theft auto. He proceeded to be arrested the very next day after his release for a trespass and bonded out on a $25 bond on that. Additionally, his criminal history includes 2013 resisting without violence, 2012 burglary of a dwelling, where he was sentenced to just over 26.5 months in state prison, 2011 resisting without violence, 2011 resisting without violence. So if the court, in your discretion, decides not to take any action on the open pending grand theft auto, I would be requesting pretrial release with the GPS monitor level 2 on this case.
What's the case number on the grand theft?
185863 CF10A.
Counsel, do you want to be heard on that?
Judge, my understanding, if Judge, I'd ask you at this time, if Your Honor is inclined to take action on the case that he's out on, I'd ask you at this time not to impose a bond hold on that. I'd ask you to consider other alternatives, such as potentially, right now he's not working, so at this time we wouldn't be opposed to level 1 house arrest, so that my understanding is probably that case is still unfiled, is still pending. The cases before you are still pending. So until the state actually makes a filing decision, I'd ask you to impose level 1 house arrest so he can wait on that decision from the outside.
Is the grand theft charge filed?
No, but it's only been a couple weeks. We haven't really had a lot of time.
Okay. On I do find probable cause as to each of these. On count 1, burglary. On this one, I'm going to set bond in the amount of $5,000 on count 1, and count 2 is $25. Count 3 is $5,000. As to case number 185863 CF10A, where the defendant was charged with grand theft and posted a $1,000 bond, the court is going to revoke his bond on that case and hold him without bond until further order of the court. If he is released on the bond on this particular case, he is to have no victim contact whatsoever. You going to do a short order on that for revoking the bond?
Yeah, I'm preparing it right now.
Okay. The basis, just so the record's clear, the basis for my revoking the bond is that I do find probable cause on this new case. Richard Daniel Ortiz.
Who's here present, Judge Maine?
Mr. Ortiz charged with grand theft. Also charged with criminal mischief. Looks like that's charged as a misdemeanor charge. I do find probable cause as to each of those offenses. Counsel, do you have anything you want to say with regard to bond?
Judge, yes. Speaking Mr. Ortiz, he advised me right now there's nobody that can help post his monetary bond. He lives in our gate. He has an address. He has a job. But right now he's no one can post his bond, so we're going to be asking you to consider releasing him on pretrial release.
State, do you have any priors?
Yes, 2015 possession of PVP. Second 2015 possession of PVP. He violated probation on those 2 cases. Attempted purchase of cocaine 07 and a petty theft in 04. There was a 1998 attempted robbery in the 2nd degree out of the state of New York. It appears he was sentenced to 5 years in state prison.
Okay, I do find probable cause. Bond is set in the amount of $1,000 on the grand theft charge.
And Your Honor, we'd be asking, because of the nature of this
No
offense,
contact with the victim whatsoever in this case. You understand, sir?
Your Honor.
You understand, sir, that if you post bond, you're not to have any contact whatsoever with the alleged victim in this case. You understand?
Yes, Your Honor. My mom just passed away, and I actually have my family bought me a ticket to go to New York on June 6th to go to the funeral. I'm supposed to come back on June 12th. I have nobody to post a $100 bill because my mom passed away. You know, a lot of money was spent.
No.
If I don't show up at this,
Judge, his brother did purchase like his airfare,
right.
So he didn't purchase it. Financially, he's indigent. Judge, he has a plane ticket already bought. The itinerary is June 6th, coming back on the 12th. You could order, Judge, that he report to pretrial upon his return. I'm sure he wouldn't object to even a level 2 and being supervised. But Judge, he's financially the $1,000 bond. No one's going to be able to post it because all their financial resources went towards the funeral. So, Judge, I'd ask you to reconsider placing him on pretrial release.
Well, if I place him on pretrial release with a GPS monitor, he's not going to be permitted to go to New York to go to the funeral.
No, you can order that basically the day before that he goes to pretrials.
I could order that, but it's not my case. So I'm going to leave the bond at $1,000, and if you want to see if you can help him get in contact with some family members to post his bond so he can go to the funeral. McIntyre Jean?
North Broward.
Hi, good morning, Mr. Jean.
Good morning.
Mr. Jean, you're here charged with possession with intent to sell or manufacture or deliver cocaine, resisting an officer without violence, possession of harmful New Legend drug without a prescription, and possession of cannabis 20 grams or less. I do find probable cause as to each of those offenses. Mr. Reedy?
Judge, I did not have an opportunity to speak to Mr. Jean before court this morning. I don't know what his financial circumstances are. Can you make a $2,500 bond, Mr. Jean? Is there anyone I can call for you to come and get you? You okay?
Yeah.
All right. Judge, could we put this on recall? Give me a chance to talk to him.
Okay, I'll put it on recall and let you have a chance to talk to Mr. Reedy, who's here with us in court this morning. Okay, Mr. Jean? So we'll call you back in just a few minutes, okay? How about Joseph Abraham Cole?
He's here at Main, Judge.
Good morning, Your Honor.
Good morning, Mr. Cole. You're here this morning charged with destroy or damage an electronic monitoring equipment. I do find probable cause for that offense. And looks like Mr. Cole, you want to say anything about bond, counsel?
No, Judge.
Okay, state.
Your Honor, I'm going to be asking for a bond increase to $5,000. Just to give Your Honor some of the history here. Mr. Cole was arrested on May 23rd of this year for tampering with physical evidence, possession of cannabis, resisting without violence. Judge Malika allowed him to be RO'd to pretrial with a GPS monitor. The reason she insisted upon the GPS monitor was his criminal history, which includes prior conviction for burglary of a dwelling with a battery, attempted sexual battery, aggravated battery, great bodily harm, armed false imprisonment, and aggravated stalking, where after a violation of probation, he was sentenced to 3-year state prison as a habitual offender. Also a previous strong-arm robbery in the mid-90s where he was sentenced to 10-year state prison. Mr. Cole came before the court on a second look, where the defense was seeking to have the GPS monitor condition taken off. Judge Malika refused, denied the motion, and apparently pretrial was then able to verify and address thereafter, and he was released. And now we're here today, as you can see. While he did turn himself in, the concern is that there was a 2-day gap in between when he admitted to cutting off the monitor, the ankle monitor, and then going to a law enforcement officer.
So what's the status of the case that he's on the GPS monitor?
Your Honor, it's still a pending case. Pretrial would be seeking that you revoke his supervision in 18-6114 CF10A, tampering with or fabricating, possession of cannabis 20 grams, and resist officer obstruct.
Okay, I do find probable cause on this particular charge, destroying an electronic monitoring device, and the bond in that case is set at $1,000. As to case number 186114 CF10A, I am going to revoke the defendant's pretrial status and enter an order at this time that he be held no bond on that case. Jason Mace or Mayes?
He's here present, Judge. I mean.
How do you say your last name, sir?
Mays.
Mays. Mr. Mays, you're here this morning. You're charged with burglary of an occupied dwelling. You're also charged with possession of cocaine, possession of cannabis 20 grams or less, drug paraphernalia possession, and drug paraphernalia possession. I do find probable cause as to each of those offenses. I will hear from you, counsel.
Judge, if we could first hear from the state, I just need a little bit more time to speak to Mr. Mace.
Okay.
Your Honor, as far as the bond on count one, I'm going to be requesting a $20,000 bond. My concern is that he went into a dwelling, in this case a room that someone was staying in while they were present, broke into the room and committed a theft. Additionally, Mr. Mace is out on bond right now for pending file charges of battery on a law enforcement officer, resisting with violence, and resisting without violence. He also has criminal history 2012, 2 counts of possession of cocaine, theft in 2010, uttering a forged instrument, and unlawful use of false name ID in 07.
Could you give me the case number on the case he's out on bond?
Yes, ma'am. It's 1711020 CF10A.
And what's the bond that's posted on that?
On the battery on the law enforcement officer is 1,000. The resisting with violence is 500. There was no bond attached to the resisting without violence.
Okay, I'll hear from you, counsel.
Judge, he's 32 years old. He's been living here for about 18 years. He's going to be contacting his family to help post his bond. He just obtained employment. He's working for a maintenance company in Hollywood. He just got his first paycheck, $200. I know his mom suffers from some physical ailments. So right now, the family, from what he's advised me, really can't come up with the $20,000 that the state has suggested. I'd be asking you to consider setting a $5,000 bond on count 1 and leaving the same bonds in place on counts 2 through 5, Judge.
Okay, I do find probable cause as to count 1, burglary of an occupied dwelling. I'm going to set bond in the amount of $10,000. As to count 2, bond is $1,000. Count 3, 4, and 5, it's $100 on each. On case number 1711020 CF10A, where the defendant is out on bond on a battery on a law enforcement officer and resisting an officer with violence, I am going to revoke those bonds and hold him no bond as to that case. And he'll see his judge on that.
And, Your Honor, and I apologize, if you didn't already order it, I would just ask for an order.
No contact with any victims in the case that I just set bond on when he's here this morning.
Thank you.
Your Honor, can we go back to Mr. Jean in the North Broward Detention Center?
Yes. Back in the North Broward, Mr. Jean. Good morning again, Mr. Jean.
Morning.
Your Honor, I've had a little bit of difficulty speaking to Mr. Jean this morning. I'm going to ask the court to consider a $1,000 bond on his case. He has provided me with a phone number that I hope is his dad's phone number so I can communicate with his family. However, right now, I really was not able to get much more information other than that.
Okay. Stay.
Just to advise the court, Mr. Jean is out right now on a $1,000 bond, possession of cannabis with intent to sell or deliver. It is filed. There are 2 other counts of possession of drug paraphernalia and DWS, but there was no bond necessary for those charges.
The case number on that case?
18-5247 CF10A.
Okay, Mr. Jean, I do find probable cause on this case. You're charged with the bond on count 1, which is possession with intent to sell, is $2,500 on this case. On case number 185247 CF10A, where you're out on bond on another case, I am going to revoke your bond on that case in order that you be held no bond on that case. someone from the public defender's office, I assume, will be over to see you on your cases.
I will let whoever is representing Mr. Jean on the other case know about today's developments.
Okay. Okay, next one is Andrew Michael Feiss.
He's approaching, Judge. He's here in Maine.
Maine. Okay, good morning, Mr. Feiss.
Morning.
You're here this morning charged with possession of cocaine, possession of heroin, drug paraphernalia possession. You're also here on, looks like a case where you're being held no bond on a violation of, is that pretrial release?
Pretrial
release. Yes, it is.
Okay. And it looks like on those 2 counts, there's no bond, and one there's $500. Is that right?
Yes.
I do find probable cause as to each of the offenses here. State, you want to be heard as to the bonds?
No, Your Honor.
Okay. Bond is set on count 1 in the amount of $1,000. Count 2, $1,000. Count 3, $100. And as I said, being held no bond on the case where there's a violation of pretrial warrant.
Yes, sir.
Tavis Khalid Jackson.
North Broward, Your Honor.
Morning, Mr. Jackson.
Good morning.
Mr. Jackson, you're here charged with criminal mischief, a misdemeanor charge here where I do find probable cause. And you're also here on an out-of-state hold, a felony case. It looks like it says from Chatham. That's a no bond hold. Pardon?
It's out of Georgia.
Out of Georgia. So,
Excuse me, miss.
hang on one sec. Let me just look at something for a minute. Does the state have any recommendation on this case?
No, Your Honor, because with the out-of-state hold, no matter what happens, he's not going anywhere until the local charge is resolved one way or another, whether it's...
Right, so that's why I said, do you have any recommendation with regard to resolving that one potentially?
Mr. Jackson did indicate he would like to resolve it if possible.
Your Honor, I have to look at the out-of-state only to see what the hold's based on. Because sometimes these are holds on violations of probation, for instance.
Right.
Excuse me.
Okay, we're just trying to look and see exactly what it is. I don't want you to say anything about the facts of your case. There's an attorney here in court. I don't know if you've had a chance to talk to him, but he's here. We're trying to see if the...
I was just going to say I knew about the Chapman stuff. I thought I already had got it resolved like a year or two ago. That's why I'm not understanding. We already came to agreement from Chapman County.
Okay, so apparently apparently they have confirmed that there is a warrant that they want to extradite you on, and that's why they placed the hold on you. Without telling me anything about the facts of your cases, would you tell me whether the case in Georgia is a probation case?
No, not at all. Never been on probation.
Okay.
Hang
on a sec.
Really, and the only real problem is it's the restitution matter that could be a problem.
Okay. So on the case here that you're being held on, it's a criminal mischief charge, and the bond is set in the amount of $100. Okay. And the other case, the case from Georgia, they have a no bond hold. So you'll need to see if they're going to come pick you up on that. Maybe someone from the public defender's office will be over to see you and can talk to you and see if they can help you, okay?
Well, generally, Judge, we have...
Right now?
Pardon?
Is there anybody I could talk to right now about that?
Well, there's an attorney here in the courtroom, Mr.
Well,
Reedy.
I spoke with Mr. Jackson, Your Honor,
Oh.
and he did indicate to me that he would like to resolve the matter. If we're not able to resolve it today, I would advise Mr. Jackson that we have extradition court on Tuesday and Thursday afternoons here.
Okay.
And at that point in time, everything can be explained to him. I cannot advise him on legal matters regarding his extradition. It is beyond the scope of my authority as a public defender.
So, Mr. Jackson, as the attorney that's present here today just said, there's an extradition court where they'll bring you into court and they'll talk to you about the extradition warrant and the extradition case. So for purposes of today, I just want you to be advised that the criminal mischief charge, the new charge, is a misdemeanor charge with a $100 bond, okay? Okay.
All right, so we'll see you either tomorrow afternoon or maybe Thursday afternoon, Mr. Jackson, here in the courtroom.
Okay, it'll be a different judge, and it'll be handling the extradition warrant that's regarding the Georgia case.
Okay, when I come back and talk about it, would they let me know everything on how I could get it handled quick as possible?
The judge is going to advise you everything you need to know about that extradition case. So just so you know, this morning what we're here on is just for me to determine whether or not there's probable cause on the new case, the misdemeanor charge. I determined that there was probable cause, and your bond is set in the amount of $100 on that case. Okay?
All right. So I got one more question.
Yes.
So with the extra stuff, the other stuff, right?
The extradition.
How come this just came out the blue? That's all I'm trying to figure out. How come nobody never came and said I had a warrant or nothing? I ran.
All I can tell you is from looking at the paperwork that I have in front of me, the paperwork shows that the officer that arrested you on this case confirmed that there was a warrant there and that they did want to extradite you. And as I said, the judge in the extradition hearing will tell you more about that.
Okay.
Okay? It'll either be tomorrow or Thursday.
All right.
Okay.
Hey, I got one more question. Can I call him again one more time? I never got it.
Called
Mr. I never finished telling him what I needed to tell him. I had to tell him something.
Well, he only represents you on the new case, not on the extradition case.
Exactly.
Okay, so you can.
Yeah, I'll call him back.
He'll talk to you again. Okay.
I'll talk to him again.
He said he'd talk to you again. Okay.
Okay.
All right.
Give me a couple of minutes though, over there, Deputy, if you don't mind.
He's in here, so give him a minute or two. Okay.
All right.
Okay, I have Mike Lorius.
He's here, President Main Judge.
Mr. Lorius has some people here from the community on his behalf.
Okay, so anyone like to come forward with Mr. Lorius? Okay, I just want to let Mr. Lorius know that there are some people here in the courtroom concerned about your well-being. Would you like to identify yourselves or not? You can come right up to the microphone there, and then he can see you. Pardon? I can't hear you. Okay, they say you should know who's here. All right?
Yeah, he knows.
Here, they're charged with possession of a forged bank bill or check, draft note, possession of a forged bank bill, check, or draft note, fraudulently uttering a false instrument, possession of a simultaneous, is that what it is, driver's license?
Similitude.
Oh, similitude driver's license, 2 counts of that. I'll hear from you, counsel.
Judge, my understanding, Mr. Lorius, he has his phone in property. He was gonna ask for a phone order, so he can call friends and family to see if they could post his bond, Judge.
It looks like he's got some friends or family here, so don't know that he necessarily
needs... They'll go ahead and post his bond.
Doesn't necessarily know that he needs to call them, but I am gonna advise you that they're here in the courtroom. State, want to be heard on the bond?
No, Your Honor.
Okay, I do find probable cause as to each of these offenses. Bond is set in the amount of $1,000 on count 1, $1,000 on count 2, $1,000 on count 3, $1,000 on count 4, and $1,000 on count 5. So a total of $5,000 is the bond in the case. Now you want to be heard? Okay, you're welcome, but in order for me to talk to you, you have to be at this podium because there's a microphone. So if you wouldn't mind approaching there, I'd be happy to answer whatever questions you have. Good morning. If you would just tell me your name. Anthony? Okay, what would you like to ask me?
I'm from Boston, so I don't know how it works. So when you say 5,000, is it like in Boston it's $5,000 exact? I don't know if you guys have the 10% here. I don't really know.
So there's an assistant public defender right here in the courtroom, and maybe he can assist you and talk to you since the assistant public defender in the jail is with Mr. Is it Lorius?
Yes.
Okay, Mr. Lorius, and so if you want to talk to them, maybe they can give you some information about that.
I'd be more than happy to help, Judge.
Okay, all right.
All right, have a seat. I'll be with you in just a couple seconds, okay?
We have Christopher Roddy.
Mr. Roddy's approaching. Come on.
Good morning, Mr. Roddy.
Good morning.
Mr. Roddy has charged with petty theft, second degree, a third or subsequent offense, and possession of methamphetamine. Also here on, looks like counts 3 through 8 are an out-of-state hold. It says Hamilton County, Tennessee. And I will find probable cause as to the charges that he's here on this morning, the petty theft and the possession of methamphetamine. On count 1, it's a $750 bond. On count 2, it's a $1,000 bond. The bond amount's already set by the judge in Tennessee, $10,000 on count 3, $81,000 on count 4, $3,000 on count 5, $4,500 on count 6, $6,000 on count 7, and $6,000 on count 8. So, Mr. Roddy, it looks like as to these cases here, it's $1,750 on the local charges. The other charges are from out of state, and those are already set by another judge.
Yes, Judge.
Okay. Isaiah Serrano.
He's approaching.
Good morning.
Good morning, Miss.
Mr. Serrano, you're charged with possession of alcohol by a person 21 years of age or under, disorderly intoxication, resisting an officer without violence, and corruption by threat.
Mr. Serrano's girlfriend is present, Your Honor.
Would you like to step up, ma'am? Okay. Good morning. If you would just state your full name for me.
Laura Lacarriere is my full name.
Okay. Can you spell your last name for me?
I don't know how to spell in English.
Okay.
Unfortunately, her English is not the best, Judge.
Okay. So just so Mr. Serrano knows, I don't know if, can he see her?
Yes, he can.
Okay, so your girlfriend is here. She's indicated that her English is not that good, but I'm going to talk to you directly. You have an attorney with you, just so that you know that she's here on your behalf, okay? I do find probable cause as to each of the offenses. I will hear from you with regard to the bond.
Judge, my understanding is he has no record, so we're going to be asking a $1,000 bond on count 4. He is 19 years old, been here for about 5 years now. He's working at a restaurant as a server, making about $5 plus tip. He lives in Miami. He is going to be counting on his girlfriend to post his bond. I believe she also works at a restaurant. So, Judge, that's the reason why we're asking for a $1,000 bond.
Okay, state.
Your Honor, it's based on the allegations. I'd be requesting a $5,000 bond on count 4.
Okay, I'm going to, as I said, I do find probable cause. As to count 4, I'm going to set bond in the amount of $2,000. And as a condition of that $2,000 bond, he is going to be supervised by pretrial release. Is the address in Miami the correct address, Mr. Serrano?
Yes.
The 1500?
Yes, 15.
No, you don't have to say the whole address. Is that the correct number?
Yes, miss.
Okay, I'm gonna $2,000 bond. If you post the bond, you're gonna be supervised by pretrial release. That means you're gonna have to call in 2 times per week while you're on bond. You are required to report in person to pretrial release when you're released from custody. Do you understand?
Do you understand?
Does he understand? Does he need an interpreter?
No, Judge.
His girlfriend's saying yes.
Yes.
Does
he need an interpreter? No. Well, I can hear good.
Can he?
Judge,
I understand. I understand you can hear me. The question is, do you understand me?
Yes.
So what is it that you need to do when you get out of jail?
I will be on pre-chart. They call me for two times a week. I go back to my work, my studies, my boxing, my stuff. That's it.
Okay, and you are not to consume any alcohol. No alcohol.
No.
You understand?
No alcohol.
You understand?
Yes.
You're subject to random testing. That means pretrial release can test you. You understand that?
Yes, I do.
Okay. You have a question?
Yeah, can somebody explain for me because I don't understand?
Anybody in here speak Spanish? I don't have an interpreter in here now.
So what I have to do, I have to...
The bond is $2,000.
Judge, I can speak Spanish and basically
Maybe you just tell her what.
Hector, can I put her on the phone with you?
Yeah.
Okay.
Okay. Let me call over there.
We're going to let you speak on the telephone.
Is that your phone or her phone?
Thank you, Judge.
Okay. Dennis Eugene McCrae.
Mr. McCrae is approaching, Judge.
Good morning, Mr. McCrae.
Good morning, Your Honor.
Mr. McCrae, you're charged with grand theft, also charged with trespass and possession of burglary tools. I do find probable cause as to each of those offenses. Thank you. State wish to be heard on the bond?
I'm not seeking any modification.
Okay. Defense?
Judge, no, we're not going to be seeking to modify it. We're just asking for a phone order, Judge.
Okay, so bond is set on count 1 in the amount of $1,000. Count 2, it's $25, and count 3, it's $1,000. You're not to have any contact with the alleged victims in this case, and I will sign a phone order.
Thank you, Judge.
Russell Rayvon Gerald.
Your Honor, if I could be heard on this case, before you make the determination, if I could be heard.
Okay, the state has asked to be heard before I make a determination.
Your Honor, I checked his driving record. On count 4, his license is not permanently revoked, and it appears, based on the language used, the officer's intent was to charge him with an operating without. It is suspended. Either way, I have no objection to an ROR on count 4 in light of the other charges.
Okay.
It looks like he's never gotten a license, and his privileges are suspended.
It does. It does appear that no license was ever issued and that the privilege is in fact suspended. So I do, as to Mr. Gerald, you're charged with grand theft, trespass, possession of burglary tools, and driving on a permanently revoked driver's license. I do find probable cause as to counts 1, 2, and 3. And as to count 4, I'm going to release you on your own recognizance. Bond in count 1 is $1,000, $25 on count 2, and $1,000 on count 3.
Judge, the only thing I'm going to be asking for is if the court would consider an ROR on count 2 alone. I don't know if the state has an objection. He did give me the phone number of his mother, so I plan on calling her after court so she can post his monetary bond.
Fine with an ROR.
Okay, so we can do an ROR on count 2 as well without the state's objection.
And Your Honor, the court on this one as well.
There's going to be absolutely no contact with the alleged victims in this case. You understand, Mr. Gerald?
Yes, ma'am.
Okay.
Thank you, Judge.
Anthony Craig Richardson.
Mr. Richardson's approaching. Good morning.
Good morning. Mr. Richardson's charged with possession of drug paraphernalia and driving with a suspended license as a habitual offender. I do find probable cause. State want to be heard?
No, Your Honor.
Judge, we're going to be asking for Mr. Richardson to be released on pretrial release. Unfortunately, he lost his job. He's 54 years old. He's been here his whole life. At this time, Judge, he is homeless. However, he did inform me he has a mailing address. He does have contact with the criminal justice system, but I believe he told me the last contact he had was approximately 2 years ago. Considering these are nonviolent offenses, I'd be asking you to release Mr. Richardson on pretrial release.
Okay, as to count 1, looks my paperwork says it's already been changed. Is that it was a medical reset?
Yeah, I am.
You show it as anything?
On count 1, I don't have any notes on my paperwork.
My paperwork shows that a previous judge had made some notes with regard to setting a bond on that.
The one thing I'd want to advise the court of.
Okay.
Yeah.
What did you want to advise me?
1, he's got a $2,000 warrant out of Dade County from 2012 for failure to appear on a DWLS. It also appears that he is registered in the state of Florida, Your Honor.
Okay, so on count 1, the possession of paraphernalia, I'm going to set bond in the amount of $500. On count 2, driving while license suspended, bond is set in the amount of $750. Martise Terrell Pointer.
It's a medical reset, Your Honor.
Okay. That's all I have. Does anybody else have anything else?
No, Judge. What time would you like to start this afternoon, Judge?
It's not gonna be me this afternoon. It's somebody else handling it. I have a regular docket in my division this afternoon, so I'm not sure actually who's handling it. I can find out if you want to call my chambers. My assistant would be happy to tell you who is handling it.
Thank you, Judge.
Okay.
Thank you.
Oh, it is Judge Miranda. It is Judge Miranda.
Thank you.
Okay. I don't know.
I mean,